Okay. Mute.
Okay, can you hear me? Hello? Can anybody hear me? Hello, interpreter? You're muted. Hello, hello? Testing, 1, 2, 3. We the people, for the people, by the people, do the people. Hey, I don't hear the interpreter.
You don't hear the interpreter now?
It looks like she's muted on the screen. It looks like her Zoom mic is muted.
She's talking to the users.
Okay, well, I don't hear anything.
Okay, mute this one.
Okay. I unmuted.
Now I hear you.
So then I have to keep it unmuted on Zoom?
Hold on, I'm gonna head to the courtroom right now. Hold on.
Okay. Okay. How about there? I can hear you. Hey.
Okay. So. Talk to me.
Okay, can you hear me?
Yes, you
On
hear
both.
me? Okay.
So then I do have to keep Zoom unmuted
When you're talking to
when I'm
me,
talking.
right?
Okay.
And how are they hearing you in the courtroom?
Can you hear me in the courtroom?
Oh,
And how about in the courtroom, Judge? Yeah?
okay, I'm not hearing the judge speak. Oh, wait, he's muted.
No, because I just muted it right now, Louis. So I'm unmuted right
There you
now.
go. Now. Okay, let's try it now.
Okay, so unmuted on Zoom and unmuted on the system.
Okay,
Still
Mr.
getting
Krause,
slight-
can I hear you?
So in the courtroom, he gets an echo.
Okay, but I don't hear him. Can you talk again?
Hello?
Oh,
Hear
there
me?
you are. Yeah, now I hear you.
Is there really a here to hear? Hello?
Yeah,
You gotta be like right to.
there I hear an echo from the headset.
Oh, I'm sorry.
Oh,
Oh, sorry. That should,
no, still an echo.
okay.
And only the interpreter has the
Yeah, echo.
Yeah, and when he speaks, he's coming in and out.
Testing. 1, 2. May headset. In May headset. Testing.
Okay, I'm hearing Eddie, I'm hearing you.
Okay. Testing. 1, 2.
I still hear Eddie.
I hear her. You gotta pick your voice.
And now?
I hear you.
I
Yeah, I still hear Eddie.
Testing. It,
Just make sure I'm clear. When he's on the headset, it's a private conversation. I shouldn't be hearing, right?
do you want to go through the process of
You're
I get
breaking up.
summon and an inmate puts on the headset?
You're faded in and out.
Yeah.
I'm waiting.
Yes.
I don't know. Any suggestions? Echo was being produced by. It's not. That's all. There's two.
Yeah.
Which is this one and my head. That not there. That's not. It's not act. The speaker's not even on.
1, 2. 1, 2.
I don't have the Zoom computer with the mic. I joined the session without any audio. Again, no, it's not muted.
Okay, can you have, Moses, can you go over to 5-3 and you'll set that one up and I'll be back? And you guys continue?
Okay, you want to go? All right, I'll verify. So the Zoom session I have, the audio, the audio portion is
Recording stopped.
is specifying to join audio. That means initially when I joined the session, I chose not to do it with audio, only video. So it's not coming from that Zoom mic, meaning this one. Now check this here. They have the song is unmuted on this area. Are you here? I can hear you. What was your question? Check the computer that this area is. In the waiting area is the same thing. The CT, I believe. What is it? Just to verify. Okay, so 3 Zoom computers. Hearing, see, waiting. All audio is disabled on all those Zoom computers. And if I stutter, I sound confused or disoriented, it's because I'm hearing myself. I hate the sound of my voice.
Hello, what about now?
I hear a slight echo, like you're.
Test.
That one's better. Let's see if I can wave.
Test. 1, 2.
Is the echo? Testing. 3, 3.
1, 2. Yeah. Still have echo here.
Still have it.
Yeah.
So I muted, like maybe, you know. And that one is off, right? That one back. No light up. Okay. Oh. Where are we at? I do need this on. Right? That's for public defense, correct? The podium, Lester?
Yeah, okay, I'm talking to headset now.
I hear you. I'm hearing you from.
Okay, it's better now. I don't have echo now.
Yeah, I can hear you from the headset speakers.
Test. Same thing. Yeah, because I have Zoom open.
Yeah. I only do. I do this one. Want me to open it real quick? Test 1, 2, 3. Test 1, 2, 3. Go ahead. Okay. So it doesn't count each other. That's good. Okay. Is anybody commuting back there? Yes, I'm in the control room. Testing. 1, 2, 3. Testing. 1, 2, 3. Testing. 1, 2, 3. In May heads. In May heads. In May heads. 1, 2, 3. Testing. 1, 2, 3. Oh, you? Yeah. Are you on station? Yeah, I hear you. Yeah, hear you good. Hear you good. From the headset. I only hear you since I'm now hearing you from the speaker. Yeah. Loud and clear. Okay. Yep. Hear you just from the headsets, not hearing it from the speakers. Now I hear you from the speakers. Not the. Okay. Only the speakers.
Talk to this room.
Yes. Yeah, he was in the headset and with the speaker. Only the headset. Yep, headset only. I don't hear the speaker. The only microphone you are getting picked up from is the one on the headset, hypothetically. And still that's
Test.
interesting. We gotta like some. Yeah, headset only. Yes, I just from the headset. Yes, I headset the speaker.
That's
Same thing. The headset and the speaker.
this. 1, 2.
Yep, same thing. Only headset. Here only from headset.
One,
Yep, only from headset.
test. Test. 1, 2. Check.
Yeah, both headset and speaker.
Hmm. Test. 1, 2. Check.
Speaker and headset.
1, 2.
Speaker and headset.
Okay, when we were testing at the beginning, it was only with the new system, right? That was before Luis had the Zoom computers, right?
Now you're getting it or your voice overlay, if that makes sense. Like your own voice is coming up. Yeah, it's better. Yeah, pick your voice. So you only had one microphone, and that was the one, and still that was producing an echo. Or is it coming? Wow. Yeah. Okay. They are. They are. I mean, I can close the session and then you can test it there.
Who's coming back? You don't know right
Yeah. You also, Brian, you know, hear it yourself from there. Set. Yeah, I hear myself blasting.
So, I'm back.
One big gun, a lot of layers. All right. Well, we
End
found
of the
out.
court.
Okay. The interpretation resumed. Brian needs to find out some of this. Yeah, it's an extra audio input that it's getting from someone. Okay.
Okay, so,
Thank you, misinterpreter.
all right.
now?
I hear you through the speakers. Yes, right now.
I hear you also.
Oh, okay. I don't have paper now, but she go out the computer.
Okay.
She logged out of Zoom.
Yeah.
Okay.
I have paper now. So it's something when she has two system.
Yeah.
Yeah. Good. It's better now. Don't have paper.
Yeah.
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 It's either or. You can't have your cake and eat it.
Even with the mind unit.
Yeah.
On Zoom, I
Ah.
have it now. So it's close. I have the Zoom in my computer.
Okay.
They go slow.
Yeah.
Mhm.
So I guess basically we're gonna stay with Zoom for the moment because we can do everybody as opposed to just one or the other.
Mhm.
Yep.
Okay, all right,
So right now, house.
okay,
Sitting. I'm
right.
Yeah.
Okay,
Okie dokie.
all right, if there's anything else, I need to go start the other courtroom, so.
Okay, we gotta go.
We're doing what,
Or we already tested, so we're ready to roll.
yeah, okay, so I'm gonna shut it down for the moment.
Okay.
They probably won't start in here probably for another 20 minutes or so,
Okay. We'll
but
be.
okay.
All right. Awesome. Thank you, guys.
Thank you.
Recording in progress.
All right, because I don't know how to promote anyone. All right, good morning, everyone. I'm Judge Espinosa Dennis. I'll be presiding over the felony bond hearings. Need to swear in the interpreter, please.
An interpreter, are you there?
You can see her here.
Please raise your right hand. Do you swear that you will interpret Spanish? The questions asked, given ability, and that you have such ability? If so, say I do.
I do, Olivia Bruce, certified court interpreter.
So all of the defendants have been sworn in, correct? Okay. All right, you may have a seat, please.
Pueden tomar asiento, por favor.
Purposes of these hearings, there's a video that has been played to all of you in English, Spanish, and Creole. I also want to let everybody know that I'm going to be appointing the public defender's office only for purposes of this hearing, first appearance, unless the court finds that you otherwise do not qualify. Okay, all the attorneys, would you please state your appearances for the record? The assistant state attorney and the PD, if we have them here.
ASA Monica John on behalf of the state. Good morning.
Nessa Ath on behalf of the state. Good morning.
Good morning.
Good morning, Your Honor. John Wilson, Assistant Public Defender.
All right, good morning. All right, okay, so we'll start with the out-of-state extraditions. Sure.
Nessa, we still haven't received the paperwork. Hello, Nessa? Nessa, can you hear me? We still haven't received the paperwork from the state attorney's office this morning.
Oh boy. So what does that translate to? Oh. Oh, okay. And does that prevent us from proceeding with extraditions? Okay, we can do the extraditions. Okay, so we'll start with the out-of-state extraditions. The first case is Giovanni McKenzie. Or BSO? Okay. This is a warrant that I have in front of me.
Right.
Oh, it's a new case. Okay, I got it. And
Your Honor, you called for Mr. McKenzie, correct?
I can barely hear you.
You called for Mr. McKenzie?
Yes.
Okay, he also has a new felony on page 4, and he's also a fugitive from Broward County with no bond.
Right, I was told that he has a hold for BSO, right? And I have two cases, the F25-22089, and I think the new cases are 22090.
Yes.
Okay.
That's great.
Oh, you have this one? Okay. He's on probation in the F23797, but is he present before the court?
Yes.
Okay, there we go. All right, good morning, Mr. McKenzie. You're here on a couple of things, sir. You are here on the out-of-state extradition calendar. Looks like there's a warrant out of Georgia. Okay, it's in case number F25-22089, and that is for the crimes of fleeing or attempting to elude a police officer, fleeing or attempting to elude 2 counts of fleeing or eluding a police officer, 1 count of aggravated assault on a peace officer and obstruction of an officer. Let me just take a look at this. There's no bond on this, okay? In addition to which, and then I'm gonna ask you whether you wish to, waive extradition or contest the extradition. If you waive extradition, as soon as you resolve whatever cases you have here in Dade County, it looks like you have a couple of other things. You have a new case, sir, in case number F25-22090, for resisting an officer with violence to his person. And then you have another case, F23797, which you're on probation. So on start with, is on the F23797, you're going to be held no bond until you appear before that judge. On the extradition case, sir, do you wish to contest extradition? You can contest the sufficiency of the warrant, but not the charges. If you waive extradition, once you resolve the pending cases locally, you will be able to move on, usually within 15 days. What is it? That's the quickest way to get out. Once you resolve everything, what is it that you wish to do?
Yeah, I would like to.
I can't hear anybody. I don't know what's going on.
I would like to go with that option to waive extradition.
Your mic is open.
Raise the volume here. Can you hear me better now?
Yes.
And I can hear you fine. All right, so I'm gonna put on here that you're waiving extradition. And what is a reset on this, since he's got some other matters?
October 27th, Your Honor.
All right, so we're gonna reset the extradition case for October 27th. Okay. All right, what about the new case on page 4 of the calendar, which is the resisting officer with violence to his person? Want to address that one now? Yeah, okay. All right, so I've already stated he has a hold on F23797. And this is one count resisting an officer with violence to his person, allegedly occurring on October 9th in the area of 7900 Northwest 27th Avenue. The public defender's office is appointed to represent him. Let's see here. Any argument? Not, I'm proceeding, I'm finding probable cause and setting the bond at, see here, $5,000. Okay, there we go. We need the second one. All right, good luck to you, sir. Next case is Jordan Evans.
He also has a new felony. He'll be on your PM calendar.
On the PM? Okay, thank you. Is that the 25-22133?
Yes, John.
Okay. Is this Mr. Evans? Good morning, Mr. Evans. You have a fugitive warrant out of, let's see here, Texas, Memphis, no, Tennessee. No, Texas. He was charged. I see he's charged in Texas, and it's for probation violation, tampering or fabricating evidence with intent to impair, is what it says. And let's see here, it's 100. Oh, it's no bond. What it says here. All right. Do you wish to waive extradition, sir, and or you wish to contest the sufficiency of the warrant? But I can't hear you.
Now I want to waive extradition.
You want to waive the charges? Waive the extradition? Okay.
Yeah.
Waive extradition. All right, reset on this. The same date, October 27th. Right, so that'll be reset in the afternoon. You'll be we'll address the new case that you have coming in. Okay.
Okay.
All right. Good luck to you, sir. Next case is DeAndre Hawes, Haws.
And he also has a traffic case that will be that will be addressed on the PM calendar.
PM calendar? Okay.
Yes.
All right, Mr. Hawes, good morning, sir. You're before the court because you have a warrant out of Georgia for it's a violation of probation for receiving stolen property. There's no bond on that. Do you wish to waive or contest extradition, sir? The quickest way to resolve this is waiving extradition would probably be out within 15 days after you resolve whatever you have locally. What do you want to do?
So waive. No, I'm saying you saying the waves.
Okay, when you're not going to argue. That's not going to be resolved. Whatever you have pending in the other jurisdiction in Georgia. This is just a matter of if you want to contest the sufficiency of the warrant. That's it, not the charges. Okay, then that means that within 15 days after you resolve everything, you'll be transported to address that.
All right.
Is that what you want to do?
Yeah, you said.
All right, so wait.
Sorry.
I'm sorry?
Yeah.
Okay. So waive extradition. And then this will be reset October 27.
He waived, Your Honor?
Oh, I'm sorry. Oh, so it's October 14th. Okay.
I'm sorry, it was waived, no bond, October 27?
No, that I just told October 14th. This afternoon. So that should be quicker is what you're saying. Okay. All right, let me sign this.
October 14th?
October 14th, yes, and he'll be on the afternoon calendar.
Yeah.
Thank you. All right, the next one is Ursula Fox. Hi.
Thank you.
Good morning. Good morning. All right, you're before the court because you have a warrant out of McKinney, Texas, Maine, and it's for retail theft of property over $30,000, but under $150,000 is what it's telling here. You have a choice to either waive extradition, which means you're not going to contest the sufficiency of your warrant. That's the quickest way to be moved on once you close whatever, if you have any, or you can contest the legal sufficiency of the warrant, not the charges per se. You've got to go there to take care of that. That's just the quickest way to resolve this. Okay. So is that what you want to do? I'd like to waive it. Okay. And this has a no bond. Okay. What's the reset? This one? All right, October 27 is your reset date. Good luck to you. Okay. Thank you. That's just to monitor and make sure that it's been resolved. Next case is Ramon Izquierdo. That's a quash. Do I need to on the docket just the signature, right? Okay, there you go. Thank you. Okay, the next case is Yasmin Alvarez.
Your Honor, he'll need the Spanish interpreter, please.
I'm sorry?
Present.
Spanish interpreter.
Oh, Spanish. Okay.
Your Honor, the previous defendant, I'm sorry, folks.
Yes.
Waived, no bond, October 27?
Yes. So this is Yasmin Beltran. Yes?
Sí.
Have an interpreter
Yes.
assistant. Okay, Mr. Alvarez Beltran, you have a warrant out of Houston, Texas. Means you
Muy
have
bien.
charges. Yes?
Muy bien, señor Beltrán. Buen día. Usted tiene aquí una orden de arresto de Houston, Texas.
Okay. Charges are aggravated assault on a family member.
Las acusaciones que constan en esa orden de arresto es agresión física con agravantes a un familiar.
Okay, and there is no bond on that.
Y esta orden de arresto no tiene fianza adjunta.
Okay, you said he has a new case?
It's an occasion.
Okay, all right.
Not a local case.
I got no locals. Okay, so the question I'm gonna ask is, do you wish to waive extradition or contest it? If you waive it, you would be transported, assuming you have no locals or anything is closed out within probably 15 days, so you can address this in Texas.
Entonces, señor, la pregunta que tengo para hacerle es si usted quiere eximir la extradición o usted quiere refutarla. Si usted exime la extradición, a la vez que ya estén cerrados sus casos locales, habrán unos 15 días de plazo para que puedan venir a recogerle y usted pueda ir a Houston a abordar este tema.
Or you could test the validity of the warrant, not the charges per se, the validity of the warrant. So the quickest way to resolve this, one way or another, is to go back to Texas and address it. That is by waiving extradition.
Y la otra opción que tiene es pues refutar esta orden y pelear la validez legal de esta orden de arresto, no las acusaciones como tal. La manera más rápida de resolverlo entonces pues sería presentarse en Houston para que usted pueda abordar este tema.
Okay.
Ok.
Do you want to waive extradition?
¿Quiere entonces eximir la extradición?
Y si no recibe la extradición, ¿qué pasa?
And what would happen if I don't waive it?
Well, you can contest the sufficiency of the warrant. You could be held up to 90 days. It's not the charges or the merits of the charges. So you have to make a decision.
Bueno, si usted quiere refutar esta orden de arresto, usted estaría refutando la validez legal de la orden de arresto. No estaría peleando las acusaciones, sino la validez de la orden de arresto y podría estar retenido hasta 90 días en las cárceles.
No, que me manden por usted todo, si la señora quiere.
No, send me to Houston then, ma'am, if you want to.
So it's a waiver of extradition. No bond, and the reset date is also October 27th? Okay, so October 27th.
Muy bien, señor. Entonces vamos a poner aquí la exhibición de la extradición y vamos a ponerle en calendario para el 27 de octubre para confirmar que haya sido trasladado.
Good luck to you, sir.
Buena suerte, señor.
En octubre me trasladan.
I'm sorry?
So on October 27, I would be transferred there?
No, this is for the court to monitor to make sure that you have been moved on. It's not that's when it's going to happen. It could happen before, okay?
No, señor, esa fecha es para que nosotros nos aseguremos que ya ha ocurrido esta transferencia, monitorear el caso de que la hayan transferido. Puede ocurrir antes, de hecho, no quiere decir que ese es el día que le van a transferir.
Okay, gracias.
All right, good
Okay,
luck.
thank you. Buenas
Calvin
tardes.
is free.
Yes, Your Honor.
Your Honor, his locals are.
Sure, Western.
Eight.
Okay.
Back to reset.
All right, my understanding is locals are set for, for the 8th, you said?
December 8th.
So let's reset this for December the 9th.
I'm sorry, what was the date?
December 9th. We're gonna reset because his locals are set for the 8th to make sure that everything has been resolved, okay? And right now, there, so you're at Metro West too? Yes, okay.
Your Honor, it looks like he closed his cases on October 1st. He was convicted at DTF. If correction can confirm, we can start the extradition.
That's correct.
Okay, so, let's see here. So his locals are closed. And then we just have to monitor to make sure that he's transported, correct? So how much time?
For October 27th.
All right, so let's reset October 27th to make sure that we've been transported, okay? That's just for us to keep an eye on what's going on, all right? Good luck to you. Sir. Next case is Gregory Yasu.
Yeah, he's in 4D, reset.
Your Honor, Colorado decided not to extradite. We're quashing those.
So you just want to quash the warrant, okay? So I'm being told that Colorado decided not to extradite him. Do we need to monitor this at all? No? All right, I've quashed it. Next case is Brandon Sartor.
He refused, Your Honor.
His locals are set for December 10th. We'd like to reset December 11th.
Okay. Locals to pending, correct?
Correct.
Okay, and then the date that you said reset just to monitor is December what? 11. All right, very good. All right, that concludes the out-of-state extraditions. Now we're going to move on to the in-state. All right, the first case is Jose Aladro. Is that you, sir?
Mr. Alondro has two warrants, one from Lee County, one from Orange County, and he has an AC no bond.
From Lee and Orange County, both, correct? Okay. All right, Mr. Aladro, good morning, sir.
Morning.
You have two warrants, sir. One from Lee County, and then just see what it says here.
Your Honor, he'll need the Spanish interpreter also.
Oh, okay, sure. Yeah. We need
Bueno, buenos días, señor. Usted tiene aquí dos órdenes de arresto. Una proviene del condado Lee, la otra proviene del condado Orange.
Okay.
Sí,
I just need to inform you. I don't think you should be discussing your case. Everything is being recorded.
No, no, señor, solamente le estoy informando. No creo que necesitemos hablar del caso, que usted necesite decir nada sobre el caso. Todo está quedando grabado, recuerde.
And warrant number 25102381, it's grand theft in the third degree, and there's no bond on that. With regards to the other warrant, which is 25102380, that's for a violation of probation for grand theft, and that has no bond as well. Okay.
Muy bien, señor. Estas órdenes de arresto vienen adjuntas con acusaciones de hurto en mayor cuantía, delito mayor en tercer grado. Una de ellas es por quebrantamiento de la libertad probatoria, en la que usted estaba por hurto en mayor cuantía también. Ambas órdenes de arresto, ninguna de las dos tiene fianza adjunta.
All right, so how much time are we giving you when we're resetting these?
15 days.
I'm sorry?
15 days.
15 days? Does anybody have what the 15-day marker is?
1027, Your Honor.
Where? Oh, that's the one I see here. Oh, so these are all October 27. Okay, all right, got it. Thank you. All right, so reset October 27. It's the monitor.
Muy bien, señor. Quedan aplazadas estos dos casos para el 27 de octubre para confirmar que usted haya sido trasladado.
Good luck, sir.
Buena suerte, señor. Tenga buen día.
¿qué quiere, disculpe, qué quiere decir?
I'm sorry. What do you mean by that, by the 27?
That's the date we give it 15 days to monitor and make sure that you have been transported.
Señor, ese es el plazo en el que nos vamos a encontrar para saber que ya usted haya sido trasladado, porque les damos 15 días para que lo trasladen.
Ok, perfecto.
Oh, ok, perfect.
Antonisha Watson. Ms. Watson, you have a warrant from Orange County, and it is for failure to appear on a petty theft charge. Your bond is $500. So I will set this for report October 27, just to make sure that you can either post the bond. If not, by that time, you should be transported in about 15 days. Okay?
Okay. Wait, then she said, what?
Jose Valle Mendez.
Mr. Valle Mendez has a hold for immigration.
Mr. Valle Mendez.
Your Honor,
would,
he'll need the Spanish interpreter. Your Honor.
Yes, the interpreter?
Interpreter, Your Honor, yes.
All right. Good morning. He's here on the state extradition wanted in Orange County for unlawful use of two-way communication devices. Bond is $2,500.
Muy bien, señor. Buenos días. Usted está aquí por una orden de arresto del condado Orange por unas acusaciones que constan en esta orden de arresto de haber estado utilizando dispositivos de comunicación de doble vía ilícitamente. Esta orden viene con $2,500 de fianza adjunto.
All right. And my understanding is you also have an ICE hold. Okay.
Y también tengo entendido que usted tiene una retención por parte de las autoridades migratorias.
So I'm going to reset this case for October 27 to make sure that you've posted bond, or if you're still in, that you're transported to Orange County. Okay.
Muy bien, aplazamos su caso en este tribunal hasta el 27 de octubre para asegurarnos de que o usted ya ha sido trasladado al condado Orange o ya usted ha pagado fianza.
¿Agregaron más cargos?
I'm sorry?
¿Perdón? ¿Qué dijo, señor?
Okay.
I misspoke because he's got a hold. I don't think he's going to be able to post the bond. All right.
De hecho, no creo que vaya a poder pagar la fianza porque usted tiene la retención por parte de migración, pero bueno.
All right. Good luck to you.
Buena suerte, señor. Tenga buen día.
Okay. Jose Hernandez Alba.
And Your Honor, the services of the Spanish interpreter.
Got a minute, Madam Interpreter?
Pues, señor.
All right. He has a warrant out of Leon County. There is no bond. It's violation of probation. Looks like for a trespass, petty theft. So there's no bond. And I'm going to set this also for October 27 to make sure it's been transported.
Your Honor, the charges on the warrant you said were petty theft and what else?
Violation of probation for a trespass and a petty theft.
Thank you, Honor. Muy bien, buenos días, señor. Usted está aquí por una orden de arresto del condado Leon y aquí esta orden de arresto no tiene fianza adjunta. Es por un quebrantamiento de libertad probatoria y con acusaciones de hurto en mayor cuantía y haber entrado sin permiso. Usted estaba en probatoria por esas acusaciones y al parecer la ha quebrantado. 27 de octubre es la próxima fecha que veremos este caso aquí en tribunales para confirmar de que ya le hayan trasladado.
Una pregunta.
All right.
Una pregunta.
A question.
Yes.
Diga.
¿Cuánto tiempo tengo para que la gente de Tallahassee me venga a buscar?
How long do I have for Tallahassee to come and pick me up?
Typically, it takes about 15 days, but it could take up to 60 days. Okay? That's
You know, you said 60?
60. We can, that's why I'm setting it for October 27, so I can monitor and make sure that you've been booked out. Okay?
Típicamente, señor, demora unos 15 días, pero podría extenderse hasta 60 días. Por eso lo aplazamos hasta el 27 de octubre para confirmar de que ya haya sido trasladado.
Y si eso no pasa, disculpe, si eso no...
You need to consult with a lawyer. I can't give you legal advice, but I'm sure it can be brought up to the court's attention.
What was it before? And what if that doesn't happen? Señor, yo no le puedo dar consejos legales. Eso usted lo tendría que consultar con un abogado. ¿Está bien?
Gracias.
Thank you.
Next case is Richard Hardwick.
I believe it's a pre-trial, Your Honor.
He's on Zoom for pre-trial. Oh, there we go. Good morning, Mr. Hardwick.
Good morning, ma'am.
Okay, you're here because you have a warrant out of Broward County. And apparently it's a felony violation of pretrial services for 1 count of petty theft, 1 count of resisting an officer without violence. It says here no bond.
The cause of it was that I came here, Your Honor. That's why they violated.
You cannot hear me?
I say the cause of it because I came here, but the charge wasn't filed, and I also was innocent, so they violated the pretrial. I had standard pretrial just to call in two times a week.
All right, well, that you'll have to work out and argue in Broward County, which is where this is from. That's why I'm going to reset this for October 27th so that hopefully you will be able to be transported there as soon as possible. Usually it happens in about 15 days, okay?
Yes, ma'am.
All right. Good luck to you, sir. Next case is Jorge Suarez Patino.
Yes.
Mr. Patino, there you go. You are from Metro West, number 3. Okay. All right, Mr. Suarez Patino, you are before the court because you have a also a warrant from Broward County, sir. And let's see here. It's no bond, and it's for failure to appear on a grand theft in the 3rd degree. So I'm going to also set your case for report on October 27th to make sure that you have been transported, okay? And you do have a no bond on that. Okay, good luck. Okay, do we have a calendar and everything else for the regular? These are the outcomes. And yeah, where are, so in other words. So all of this is with this one, got it. And then the others would be the same thing, right here. This is nothing. This is the other one, okay. I'm sorry? I don't know. I can't, wait a minute, could it be on the bottom of this? I grabbed the whole goodies. Okay, all right. Okay, we're starting the, we're putting some cases out of turn for corrections. The first one I'm being told is Von Waiters. And this is out of page 8 of the calendar.
Mr. Waiters, present. Rebecca McCory, Mr. Public Defender. Good morning.
Good morning.
Good to see you again.
Likewise. Let's see here. Here we go on the bottom of page 8. All right, Mr. Waiters, it looks, I have arrest affidavit. There's 2 cases. There's case number F25-22123 and F25-22124. So the one ending in 2123 alleges that you have committed the offense of murder in 1st degree with a deadly weapon. Looks like attempt. It's an attempt to commit murder. And then there is an attempt kidnapping with a weapon or firearm or aggravated battery. At least that's what it says on the, that's that case. On the one ending in 22124, there is 1 count of possession of firearm, ammunition, or weapon by a convicted felon. 1 count possession of a controlled substance, sale, possession, or with intent to sell armed. That would be MD with MDMA. There's also 1 count of armed possession with intent to sell or manufacture cannabis. And there's also armed, let's see, possession of, another count of cannabis. On the second page, that one continues, armed possession of a controlled substance, MDMA. 1 count of possession of cocaine with a firearm. 1 count of possession with intent to sell cocaine, and 1 count of grand theft of a firearm. I've appointed the Public Defender's Office to represent you in both of these cases. The state of Florida has also filed a motion for pretrial detention pursuant to Florida Statute 907.041 in case number F25-22123. Okay. All right, what we're going to do now is I'm going to take a look at the arrest affidavits to see if there's probable cause and a basis to grant the motion in the 22123, and also in, of course, address your bond status and the same thing in the case ending in 22124. Okay. All right,
So Judge,
any other side?
I think there's PC, as the attempted murder and the attempted kidnapping. In terms of the other case, I believe there's PC as well, but some of the counts are duplicative. So the state's request in that case is $7,500 on count 1 and $2,500 on the rest, in light of some of the charges being duplicative, and then no bond on the other case.
So Judge, I would ask at best that you find probable cause for aggravated battery. It appears on the arrest.
Which case are you addressing?
On 22123. Judge, is that the one we do first?
Yes, that's what I was gonna do first.
Perfect. So on that one, Judge, it appears that the alleged victim was trying to attack Mr. Waiters with a keyboard. He also admits to stealing a dirt bike from Mr. Waiters. So there appears to be another underlying instance going on at this time, Judge.
All right, let's address one at a time. Right, the court has reviewed the arrest affidavit. Court has also reviewed Mr. Waiters' criminal history. The court finds that there is probable cause as to both counts. The court is going to grant the state's motion for pretrial detention, so he will be held no bond in count 1 and no bond in count 2.
And that's pending here on the motion, Judge.
Pardon me?
And that's until there's a hearing on the motion. So you're holding him in for the hearing.
I'm granting the motion for pretrial.
Motion to hold him until his hearing. And then after the hearing, I guess the judge will decide any potential.
Right. He eventually is entitled to a further hearing, correct?
Correct. Okay.
Okay, so that's that case. Okay, now the other case, which is the one ending in 22124. Okay, that is the one that the state is conceding that there are some of these charges are duplicitous and may not. Okay, so let's see here. The recommendation is standard bond.
So recommendation is 75 on count, 100 on count 1, and then 2,500 on the rest.
Correct.
Well, on the cannabis, just claims that there's 0.5 grams of cannabis.
We can ROI.
They're claiming he's charged with over 20 grams.
That's the one in
that's in count 3, 4. They have to duplicitous charge for this.
Well, that's why. So
count. I guess you're right on the marijuana, Miss Corey.
There's only the marijuana counts or counts 3 and 4.
Yep.
Mm-hmm.
All right, count 1, 7,500. Count 2, 2,500. Count 3. That's the one that's they're both marijuanas are 0.5.
You're gonna do $1 for that, Judge?
No objection.
The same with count 4?
Yes.
That's fine.
All right, so count 3 and 4, each $1. Okay. Okay. Count 5 is the armed possession of controlled substance, that being MDMA, $2,500. Count 6, that's the possession of armed possession of cocaine. And that one you're saying is duplicitous with the the 7 count?
So he's charging a couple counts related to cocaine, right?
2, 6, and
Right.
7.
That's why I'm agreeing to the lower bond.
Do you agree with both counts, or you're suggesting this court enter $2,500 on both 6 and 7?
Yes.
Even though. And count, so that's 6 and 7, 2,500, and then the 8th is armed grand theft.
Judge 8 is the grand theft of the firearm. The allegations is was stolen sometime in 2023.
You want to do 1,000 on that?
Or I'd ask for $1. I just can't imagine the state will file on something.
Well, it's on the 8th form.
Well, that's the police arrest.
Possession of a firearm.
The state attorney will review it and realize that they probably have nothing that ties Mr.
I'm setting bond
Waiters.
2,500.
Judge, the state was okay with 1,000.
I said 2,500. I can address and consider the state's recommendations. I don't know. All right, so just for corrections is understands count 1 is 7,500, count 2 2,500, counts 3 and 4 each $1. And that's primarily because of the amount of the duplicitous number 1 and number 2. There's only 0.5 grams of the cannabis involved. Count 5 is 2,500, count 6 is 2,500, count 7 is 2,500, and count 8 is 2,500.
There's 2 more counts.
Oops, wait a minute. Where? Oh. Okay, so I didn't even read those. Count 9 is possession of a weapon during the commission of an offense, 3rd-degree felony, and another possession of MDMA, which is duplicitous on the count 2.
Would you do $1 for count 9 since it's really included in the other charges, Judge?
Okay, so let's do count 9 on this one. $1. And then count 10. Actually, gotta be the other way around. Count 9, count 10 is gonna be $1. And count 9 is 2,500. Got that corrections?
Yes, count 9, 2,500, count 10 $1.
Yes. Okay. All right. There is a stay away order in case number 20 F25-22123. Mr. Waiters, that means if you're able to post bond or get out, one of the conditions is that you cannot have any contact, direct or indirect, with the alleged victim in the case, Carlton Ross. That means no contact in person in writing, by telephone, by pager, by fax, or through third persons. He must stay at least 500 feet away from the victim, victim's home, place of employment, school. At all times, no electronic contact such as emailing, texting, Facebook messaging, or Twitter is prohibited. You understand that, sir?
Yes, ma'am.
All right, good luck to you. Okay. What's this one? Oh. Just, it's a bit, I just signed one, so let me just. All right, the next one that's going to be called out of turn is Michael Ramos on page 10 of the calendar.
Present, speaks English.
Morning, Mr. Ramos.
Morning.
Ramos. How do you pronounce that?
Ramos.
Ramos. All right. Here before the court, it's alleged that you committed the offense of possession of a firearm, weapon, or ammunition by a convicted felon. And this is on October 9th in the vicinity of 1355 Alabama Avenue.
Good morning, Your Honor. Marco Gasal on behalf of Mr. Ramon.
Oh, there you go. I'm looking at.
Yeah.
So you're representing him?
Yes, ma'am.
Okay, terrific. And what is your name? I'm sorry, sir.
Marco Gasal.
Quesada. All right, so I'm discharging the public defender's office.
He also came in on a bench warrant misdemeanor. He'll be going to jail remand after this.
Okay. All right. Okay, all right, so, as I said, 1 count of possession of a firearm by convicted felon. Let's take a look at, taking a look at the arrest affidavit. Have you had the benefit of that, counsel?
I do.
Let me just take a quick look at it, and I see his priors. Okay. All right, do you have any argument, counsel?
That's, I would ask for, Your Honor said, it's not, actual possession seemed to be found under a mattress. I would ask for a, bond of 2,500.
Was the state's position on this?
7,500, that's the state's request.
Which is a standard bond.
Yeah.
All right, I'm gonna set standard bond. There's really not, this is pretty, he's not on any supervision, but he has had significant contacts with the system and been on probation, so, $7,500 and,
What's the amount, Judge?
I'm sorry?
What's the amount?
7,500.
Oh, okay, I was asking for 2,500.
No.
Okay, would Your Honor consider 5,000?
We're not bargaining here. He's got, good try, you get an E for trying, but, he's got some contacts with the system and it's pretty straightforward, okay?
Your Honor, that was 7,500?
7,500, yes, okay?
Corrections, should the attorney go up to 5,300 right now?
Yes.
Okay. Next is, I'm missing one. Is this? Oh, this is the 8th one here. Oh. Okay, all right, the next case is out of page 11. And this is Mr. Ernesto Jimenez. He has 2 cases.
He speaks English and Spanish.
Okay, okay, all right, good morning, Mr. Jimenez.
Morning, ma'am.
All right, you have 2 cases, sir. You have F-25-22108, where the alleged, well, it supposedly took place at this game time located at 7320 Southwest 59th Avenue, and F-25-22109, it looks like, and that's at the Sushi Sake at 9565 Southwest 72nd Street. The charges are, let's see, in the case ending 2108, organized fraud of $20,000 or less. And on the 2109, petty theft, 2 or more convictions. Okay, so I've appointed the public defender's office to represent you in both of these cases.
It's a dine and dash situation. The defendant's got an open defrauding an innkeeper, and it looks like he's got a couple convictions from this year also for defrauding an innkeeper. That probably should be the more appropriate charge. The state's requesting maybe $1,500 per case. Take into account that he just keeps doing this.
That he what?
Just keeps doing this.
Well, he's pending trial on one already.
Right, he's got convictions for the same thing from earlier this year.
Judge, would you consider $1,000 each for Mr. Jimenez? You think he can afford about a $2,000 bond, maybe 2,500?
He's pending trial and he's not on the same thing. And this is not the first time. The risk to the community is also a factor that's to consider. So I'm respectfully denying request. I'm setting standard bond at $2,500 in each one of the cases. Okay. And the stay away work. So let me just explain to you, Mr. Jimenez, that if you're able to post the bond, sir, you have to stay away at least 500 feet and go not anywhere near. The business is known as Sushi Sake, and I read the address, is already the game time, both of which in Miami. Understood, sir?
Yes, Your Honor.
All right. Let me just sign these for you, and then I guess we're ready for the regular calendar. Good morning. There we go. Okay. All right, starting on page 1 of the calendar, Giovanna Missel.
Coming up.
Good morning, Ms. Missel. All right, you're before the court because it's alleged that you committed the offense of aggravated assault with a deadly weapon, that being a knife. The alleged victim is a person known as Jana Michelle. Let me just see here. I'm going to take a look at the arrest affidavit to determine probable cause and address your bond status. Likewise. So this is, it's alleged it's the sibling.
Yes, Judge.
Reside in the same address.
Michelle indicates she'll have another place to stay.
She will.
Yes. I see no prior arrest history for Miss Michelle. Judge, would you consider a $3,000 bond?
I'm sorry, I didn't hear you. Sort of.
Would you consider a $3,000 bond? I see no prior arrest history. And they'll reside in different locations.
State.
Up to you, Judge. Ms. Quay, where's she gonna stay?
She'll stay with us.
It's been represented that she has another place to stay.
Yeah.
One of the conditions is that you cannot have any contact, direct or indirect, with the alleged victim. That means you can't contact the person in writing by pager, by fax, third parties. You have to stay at least 500 feet away from her home, place of employment, or school at all times. You understand that? Do you go to school? What do you do?
So
I'm sorry?
security.
You work security? All right, I'm making a finding of probable cause. I'm gonna set bond at $3,000, reduced amount with a stay away order, okay? Part of the conditions also are that you cannot engage in criminal activity, you can't use or possess any illegal drugs. You can't use, purchase, possess, or carry any firearm, gun, weapon, or ammunition. If you have any of these things, you have to surrender them to the nearest police department and to get a receipt and file it with a court. You may return one time to the residence to pick up your personal belongings and any medication you need with a law enforcement officer, okay, within 48 hours of your release. You can't go unaccompanied. It has to be with a law enforcement officer. If you violate that, you'll be back here again. Let's see here. And you understand what I'm telling you?
Yes, yes, Your Honor.
Okay, good luck. Next case is Tina Schofield.
She refused, Your Honor, receipt for PM.
Okay.
Your Honor, for probable cause?
Possession of crack cocaine.
Yes.
Hold on. Yeah, PC found. Okay, so let's reset this for PM. There we go. Next case is Iberca Moreno.
We are trying to get her into a mental health hospital. Ms. Corey, any success?
No, she did not have adequate benefits to get into the hospital.
So what are we doing this for this?
Would just set a bond.
Okay.
Standard is
Judge
5,000.
Glazer already found PC from what I'm hearing, seeing here today. And so this is one count of felony battery. Prior contacts with the system that were either crossed or no actions. $5,000 bond. Tamariona Wheeler. Is this Ms. Wheeler?
Yes, Judge.
Okay, good morning.
Good morning.
All right, Ms. Wheeler, you're before the court because it's alleged that you committed the offense of armed robbery with a weapon or conspiracy to commit thereon. Let's see what this says. And the state of Florida has also filed a motion for pretrial detention pursuant to Florida statute 907.041, asking to be held no bond. And there's also the stay away order, which if the court finds probable cause will enter, and the alleged victim's initials are, I think it's DB. I'm not sure if that's a D or an O.
It's DB, yes.
DB, okay. DB. All right, so let me take a look. I've appointed the public defender's office to represent you for purposes of these hearings, and I'm going to take a look at the arrest affidavits now to finding a probable cause and address to your bond status of the motion that's been filed. All right.
So Judge, it's the state's position that the defendant would be a principal to the armed robbery. So requesting that your honor find PC for the completed offense and hold the defendant without bond pending the determination on the motion.
So Judge, I would ask that you find no probable cause for Miss Wheeler. She's accused of this crime along with her twin sister and 2 other people. However, in the arrest form, Tamarian is defendant number 2, Judge. She's not defendant number 1. So she's not accused of doing the robbery at all. It states on the last page that she knew it was about to be committed, but does not indicate she participated in it. So having knowledge that something is about to happen and not participating in it, and it means that she's not committing the robbery, Judge. There's nothing saying that she assisted in any way for this incident to have taken place. I would ask you to find no probable cause and release Ms. Wheeler outright, Judge.
All right, the court has reviewed the arrest affidavit and listened to argument from both sides. The court finds that there is probable cause. Okay, and I am I'm going to hold her no bond. I'm going to enter a stay away order, which I need you, Ms. Wheeler, to understand that if you're able to, at any point in time, post bond, because obviously there's going to be other hearings in this regard, you're prohibited from having any contact, direct or indirect, with the alleged victim whose initials are DB. That means no contact in person, in writing, by phone, page, or fax, or to third persons. You must stay 500 feet away from the victim, victim's home, place of employment, or school at all times, which means no electronic contact such as emailing, texting, Facebook messaging, or Twitter is allowed. You understand that? Yes? Okay, good luck to you, Ramon. Next case is Yamida Reyes Ramos. Two cases on this one.
Spanish interpreter, please.
Okay.
Present.
All right, morning, Ms. Reyes Ramos.
Buenos días, señora Reyes Ramos.
You have two cases before the court. First case, 25-22103, alleges you committed one count of insurance fraud by staging an accident, one count of organized scheme to defraud or conspiracy to do so, one count of criminal solicitation. The other case. Oh, I'm
Buenos
sorry.
días, señor. Thank you, Honor. Buenos días, señora Reyes Ramos. Usted está ante este tribunal a responder por dos cargos. Uno de ellos, número 2522103, consta con una acusación de fraude a un seguro a través de un accidente montado ficticio, una acusación de organización o confabulación para cometer fraude y además de solicitud penal o criminal.
Okay. In the other case, which is case number F25-22104, it is alleged that you committed one count of insurance fraud by staging an accident, one count of grand theft in the second degree, which is $20,000, but no more than $100,000. One count of conspiracy to commit grand theft in the second degree, the same thing, but that's conspiracy. It looks like one count of organized scheme to defraud, one count of conspiracy to commit organized scheme to defraud, one count of filing a false report of a crime to law enforcement authorities, and one count of criminal solicitation. I have a point. Go ahead.
En el segundo caso, F25-22104, usted está enfrentando acusaciones de fraude a una compañía de seguro a través de un accidente montado ficticio, además hurto en mayor cuantía, que es un delito mayor en segundo grado, conspiración para cometer hurto en mayor cuantía, además de confabular u organizarse para cometer un fraude o estafa organizada, además el haber reportado un accidente o incidente falso a los oficiales del orden público y además el haber organizado un fraude o confabulado para estafar o defraudar.
Okay. I've appointed the public defender's office to represent you.
Le he asignado al abogado de oficio para que les represente.
And now I'm going to take a look at the arrest affidavits to determine the probable cause and address your bond status. Okay.
En estos momentos voy a echarle un vistazo a revisar el informe de arresto para determinar motivo fundado y causa probable en cuanto a su arresto.
All right, let's address 25-22103 first.
Vamos a comenzar con el caso F25-22103.
Judge, would you consider pretrial services for Ms. Reyes Ramos? I see no prior history for her at all.
La defensa le solicita a su señoría, ¿podría usted considerar, por favor, el programa de servicios previo a juicio para la señora Reyes Ramos? Yo no veo aquí que conste ningún antecedente en lo absoluto.
These charges are non-violent in nature, Judge.
These are two.
Estas acusaciones no son de índole violento, su señoría.
These are two cases of the same thing occurring in close proximity.
Estos son dos delitos de la misma índole, dos delitos similares ocurriendo próximos uno al otro, o sea, cercanos.
Request for pretrial is denied.
Su solicitud para el programa de servicios previo a juicio queda negada.
Any argument on this one? Because I'm ready to go.
Judge, would you consider a $5,000 bond total for each case?
Su señoría, ¿consideraría usted entonces $5,000 de fianza en total para ambos casos?
For both cases?
For each
¿Para
case.
ambos?
Cases.
Para cada uno.
State?
Fiscalía.
Maybe do 2,500 on all of the felony counts. Some of them are second-degree felonies.
It's a bit overcharged on the other one, especially.
Indica la fiscalía, quizás podríamos poner 2,500 en cada uno de los delitos mayores. Algunos de esos son de delito mayor en segundo grado. Indica la defensa. Eso quizás sería un poco, pues, subir un poco demasiado la fianza.
And then maybe 150 on all the misdemeanors.
Y que esas 150 en los delitos menores.
In case number, so there's probable cause on pretty much everything here. On case number 22103, I'm setting bond on count 1 at 7,500. On count 2, 100, and count 3, 100.
Count 3, how much, Your Honor?
100, count 3, 100, count 2, and 7,500, count 1.
Muy bien, en el caso que termina en 2103, van a ser en el cargo número 1, 7,500, en el cargo 2, 100 y en el cargo 3, 100.
Okay. In case number ending in 2104,
Ahora, en el caso que termine en 2104,
I'll set $7,500 on count 1. And then counts 2, 3, 4, 5, 6, and 7, 100 each.
100, Your Honor, each.
100 each.
En el cargo que termine, el caso que termine en 2104, la acusación número 1, 7,500. Y en las acusaciones desde las 2 hasta las 7 van a ser $100 cada una.
All right, good luck.
Buena suerte.
Page 2, Jenny Guevara. Ms. Guevara, my understanding, she's had 2 other contacts with the system, but no, they were either no action, no cross, correct?
Yes, state's requesting pretrial.
Okay, and the court doesn't. Okay. All right, so what we're gonna do is, I'm gonna refer to pretrial services. I do find probable cause, so this will be, would pretrial, do you need anything? Alternate bond, okay, so.
The standard is 2,500.
2,500 is the alternate bond, okay? You need any other information from her is the question, no? Okay, terrific. Good luck. All right, Katisha Lawson. Is this Ms. Lawson?
Ma'am.
Good morning.
Morning. I'm home.
Ms. Lawson, you're before the court. It's alleged that you committed the offensive battery on law enforcement officer, correction officer, firefighter on Opelika Tri-Rail on October the 9th. She doesn't have any other priors, right?
She's listed as homeless, though. I don't know what connection she has to South Florida.
So Judge, Miss Lawson is currently homeless. She only has maybe $500 for a bond. I would ask if you would consider setting a $500 bond, Judge.
I can't, you're trailing.
I would ask if you would consider setting a $500 bond.
Allegations are she spat in the officer's face.
I'll reduce it to 2,500. Because there is PC here. Okay. Good luck.
Straight bond, Your Honor?
Straight bond. Count 3, I'm sorry, page 3, Alexis. Good morning, speak English?
Yes, Judge.
All right, Alexis, you are before the court because it's alleged that you have committed the offense of 2 counts of aggravated assault with a deadly weapon and 1 count of domestic violence, simple battery. The alleged victims are Guillermina Perez de Alfaro and Roberto Alfaro. Okay. I have appointed public defender's office for purposes of this hearing. Let's see here, victim.
Ms. Carter, are you a co-host?
Pardon me?
So it looks like his family's logged on, but I'm not a co-host, so I can't with them.
They didn't make you a co-host?
Or if Miss Corey's a co-host.
I'm not.
No?
One of us, yeah.
So nobody, great. Okay, let's see here. I don't see where these. Okay, I just made both of you guys co-host. I hope that works. There we go. We're supposed to have done this earlier.
Yes, I'm gonna promote the alleged victim.
So, Mr. Alfaro, I'm gonna take a look at the arrest affidavit now to make findings of probable cause and address your bond status. It looks like this is the one thing that he's got in the system, correct?
Good morning, Your Honor.
Good morning. Okay, I can't see. I hear a good morning, but I can't see a person. There you go. Okay, you are home.
I'm his sister.
Your name, ma'am?
Giselle Alfaro.
Okay, but you're not an alleged victim in the case.
She is an alleged victim.
I thought it said Guillermina and Roberto.
That's my grandma, but I think they made a mistake because I wrote a witness report and everything.
Okay, well, I just need hold on 1 second. I just need clarification from the state because I have 2 stay away orders.
It should have just been a stay away order from Roberto and Giselle Alfaro.
Oh, Giselle. So this Guillermina is.
I think she's a witness. She was there, but she's not a victim.
So it's Giselle. How do you spell your name, ma'am? Your first name?
Giselle.
Got it. Giselle. Is it Perez Alfaro?
No, it's just Alfaro.
Alfaro. Okay. All right. Okay. So how are you related to Mr. Alexis Alfaro?
That's my brother.
Okay. And why is it that you're here today? Do you wish to say anything to the court?
Yes, my brother's diagnosed schizophrenic. He takes medication. The medications haven't worked for years. He needs to be in like a mental hospital. I don't know if that's because we're like this has gone on for a long time. We call the police all the time. Like he needs real help. Like he needs to be in a like facility that he could get help at.
You live in the same place?
Yes.
You know if your brother has disability or any kind of insurance?
Yeah, he does.
Okay.
Do you know if it's Medicaid or Medicare?
I don't know the name of it. My mom knows it.
Okay. Judge, if we can reset Mr. Alfaro for the afternoon, I can see if we can get him into a hospital for treatment.
Okay, but I need to make findings of probable cause. I think that would, because I think what you're seeking is some kind of secure hospital facility that he can get treatment. But these are pretty serious, and the alleged victim has been candid with the court that this has occurred before. In other words, they're having to call the police because of the medication. According to her, it's working. So I'm going to, what I'm going to do is I'm going to make a finding of probable cause as to both counts. And what I'll do is I'll reset this for the afternoon, unless there's any objection.
I think that would be good to see if we can get him into a hospital, stabilized, and maybe get him on a
It's got to be a
different.
secure facility. Okay, so, oh, and you know, I just realized they had three. I saw another one under it. They had three proposed stay away orders. One, I see Giselle here, but also Guillermina. And so there's three of them. All right. Okay, well, it's going to be reset for the afternoon. Ms. Alfaro is going to look into the possibility of hospitalization. So I'm going to reset PM.
Your Honor, can it be card only?
I'm sorry?
Can it be card only, or do you need the defendant here?
I need to read the stay orders. I haven't
Okay,
accessed them. So let me just go ahead and read him the stay orders as soon as he finishes, and then I don't think you don't need him unless his lawyer wants him here. Ms. Corey?
Yes, Judge.
Okay, what I want to do is read him the conditions of release, because I need him to hear that. And then it's going to be reset for the afternoon, but the question is being asked, does he need to be here? It's just a matter of finding him possible facility. Okay, all right, Mr. Alfaro, listen carefully. The court has not yet ruled on what conditions of your release, if any, are going to be. I have found probable cause, but if you are released at any given time, sir, the conditions of that release are going to be as follows. And I need you to tell me at the end if you understand what I'm saying. You cannot have any contact. You're prohibited from having any contact, direct or indirect, with the following people: Giselle Alfaro, Roberto Alfaro, and Mina Alfaro. Okay, that means no contact in person, in writing, by telephone, or through social media. You have to sit at least 500 feet away from each of these individuals, their home, their place of employment, or school if applicable at all times. Do you understand that?
Yes.
Okay. You cannot engage in any criminal activity. Okay. You cannot use or possess any illegal drugs. You cannot use, purchase, possess, or carry a firearm, a gun, a weapon, or ammunition. You must immediately surrender any firearms, ammunition, or concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand that? If you have any of these things, okay? All right. Okay. Our next case is Juan Gil.
Thank you, Your Honor.
You're welcome.
Mr. Hill has 5 misdemeanors and he will be going for those cases in the afternoon for jail arraignment.
Yeah, the mic is trailing away. Do you hear? I mean, it's just sort of like.
Can you hear me now, Your Honor?
I can, but it's.
Okay, he has 5 misdemeanors. They're petty thefts. He'll be going for those in the afternoon for jail arraignment.
Okay, all right, thank you. All right, Mr. Hill, good afternoon, or rather good morning, that's wishful thinking. You have 2 cases before this court. One of which, first of all, do you speak English?
Yeah.
Okay, one of which is, let's see here, case numbers F25-22081 and F25-22097. You with me? It's important that you understand what I'm saying, okay? On the case ending in 22081, you're charged with, let's see here, retail theft, multiple thefts within 30 days, okay? And that's at the Harbor Freight Place at 2855 Northwest 79th Street, occurring yesterday. The other case ending in 22097, again, it's a multi-theft occurring within 30 days, is what it says. And 1 count of grand theft in the 3rd degree. And that supposedly took place on September 15th of 2025 in the vicinity of 7910 Northwest 27th Avenue. I've appointed the Public Defender's Office to represent you. I see here that one of the proposed stay away orders is that if you are able to post bond, released, or any other conditions of release, you have to stay away from Harbor Freight, rather, the other way around, and Walgreens. Okay, so let me take a look at these arrest affidavits. And all the others, I assume corrections or petty thefts, as I'm looking at the, it looks like.
Yes, they're all petty thefts and misdemeanors.
Got it.
Ms. F, do you agree it should be 1 count of grand theft and 1 count of petty theft?
Yes. And then the petty theft would be a 1st degree misdemeanor. We could split our R1.
Yeah. All right, case ending in 22081.
I'd have probable cause for 1st degree misdemeanor petty theft, Judge. The value is 99.
I've never seen, it's now, at least I've never covered this multiple thefts within 30-day offense. Is this new now?
I don't know
Maybe
if
it's happening and I just had never had it before in terms of.
I don't think it's new. I just don't think that it's charged very often.
And it's not charged correctly here.
You said Nessa?
Right, I don't know if it's new, like Ms. Corey was saying, but it's not
Oh,
charged.
and I didn't mean that in terms of enforcement, I guess, for lack of a better word, because I've
Oh.
never seen it.
I don't know, but it's
Not
not
that it
charged
doesn't
correctly
exist.
here.
Okay, so the recommendation is that on a misdemeanor?
Right,
Yes.
so the bond would be 500.
I'm sorry. Oh. Okay, all right, so on this one, it'll be a misdemeanor. I'm gonna set bond at $100 with a stay away order. And on the 22097, that'll be a grand theft, I assume, on the second
Right.
count.
Right. No problem cause for count 1.
2,500, and on the first one, it'll be $1. With a stay away.
$1 and 2,500.
$1 on the first count. 2,500 on the second count. With a stay away order. Hold on, guys, two papers here. to sign. This is what makes this job so difficult for people. This is what makes this job so difficult for people. Wow. Goodness. No, this one. Okay, so these are the two for this case. 1 second. You got a pile of these. Here we go. This one's staying right here. All right. This one, this gentleman is Christopher Paul. Yes? Okay. Let's take a look at you. All right, Mr. Paul. You're before the court because it's alleged that you committed the following offenses, sir. 1 count of battery, domestic battery by strangulation, and 1 count of simple domestic battery. The alleged victim in the case is a person by the name of Amanda Russo. Okay. So any conditions of release will include a stay away order, which means that you cannot have any contact, direct or indirect, with the alleged victim in the case. That means no contact through social media, in person, through third parties, or by phone, pager, anything. You have to stay at least 500 feet away from her. Okay. All right. What is the public defender's office to represent you? Let me take a quick look at the A forms. Your last name is Rigo, right? Yes. Is the victim present, Ms. Nelson? No?
I don't believe so. All right, there's probably cause here. All right, I find probable cause. I'm setting bond on count 1 at $5,000. And count 2.
Would you do $1? Two judge?
$1.
Thank you.
Okay. The stay away order, sir. You can't, I already explained to you the no contact. You can't engage in any criminal activity. You cannot use or possess any illegal drugs. You can't use or possess any firearms, weapons, or ammunitions. If you have any of those or permits, you have to surrender them to the local authority, police authority, get a receipt, and file it with the court. If you have any belongings at the residence, because the A form alludes to the fact that you've been living together, you can go back once upon your release within 40 hours of your release with a law enforcement officer. That's important for you to understand. To get your personal belongings, medication, work-related, and that's it. After that, you can't go back until further order. Okay?
So
You understand?
I do understand. But can I also?
I can't, huh?
I want to speak to that. She was
Don't speak to that. Everything here is being recorded. You have a good lawyer. You let them know. I'm basing it on the A form. This is not a trial. Oh, I signed one in the wrong place. I saw one go there. Okay, I saw it. We did this one already at McKinsey, right? Yes, we did. Yeah, okay. All right, on page 4, Stanley Vixamare. Is that Mr. you, Vixamare?
Yes, good morning, Your Honor.
Okay. Good morning, sir. All right, you're before the court because you are charged. It's alleged that you committed domestic battery by strangulation and simple battery as well. The alleged victim in this case is initials AF, okay? Any conditions of release, and we're going to be talking about that shortly, will include that you cannot have any contact with this person, direct or indirect. That means no contact in person, in writing, by telephone, by pager, by fax, or through third persons. You have to stay at least 500 feet away from this person, home, place of employment, or school at all times. Also prevents any contact by social media, electronic in nature, emailing, texting, Facebook messaging, or Twitter. You understand?
Yes, Your Honor.
Okay. All right, so now I'm appointed the public defender's office. I'm going to take a look at the arrest affidavit to see if there's probable cause and to address your bond status. All right, I find probable cause. Both of these counts, I am setting bond count 1.
Judge, would you consider a reduced bond? Mr. Vixmar thinks he could afford about a $3,000 bond. In the arrest form, Judge, on page 2, the police specifically state that there were no visible signs of any kind of injury. I think that's an important telltale, maybe what's going on, Judge. I would ask if you would reduce the bond.
I get it. I get the argument. I find within the 4 corners, there's probable cause here. $5,000 first count 2, $100 with a stay away order. That means no contact, as I read before. You cannot engage in any criminal activities. You cannot use or possess illegal drugs. If you have any firearms, weapons, or ammunition, so you have to surrender them to the police department and get a receipt to be filed with the court. If you have, it says here you live together, so returning to the
I don't know if Your Honor realizes it, but this dates back to, I think, June of 24.
Oh, it is 2024.
Yeah, so it's an older case.
And he's just now being arrested. Judge, would you consider a reduction?
Because it's an older case?
Well, if you were so dangerous, they would have had him in custody earlier.
Not without hearing the victim. My ruling stand. Good luck. Next case is Unier Honduras.
Mr. Dades for immigration.
I'm sorry?
He has an ICE hold, Mr. Dades.
Is this Mr. Unier Hondares?
Yes, Spanish, please.
Present.
All right, Mr. Andares, you have two cases before this court this morning.
Buenos días, señor Andares. Usted tiene dos casos ante este tribunal en la mañana de hoy.
Okay, in case number F 25-22099, it is alleged that you committed the offense of armed robbery with a firearm or deadly weapon.
En el caso F2522099 se alega que usted cometió los delitos de robo a mano armada con un arma de fuego.
And that incident allegedly took place on July 26th of this year in the vicinity of 6355 Northwest 7th Avenue in Miami.
Y se alega que dicho delito ocurrió el 26 de julio de este año en la vecindad del 6355 del noroeste, 7 Avenida aquí en Miami.
Okay. In case number F 25-22120, it's alleged that you committed one count of armed robbery with a firearm or deadly weapon.
En el caso F2522120 se alega que usted cometió el delito de robo a mano armada con un arma de fuego.
And this supposedly took place on September 25th, 2025 in the vicinity of 1731 Northwest 44th Street.
Your Honor, could you repeat the address for the interpreter?
I'm sorry, I'm being addressed by the clerk. I'm very sorry. Okay, what did you want me to repeat, ma'am?
The address, I'm sorry.
Okay, the address is set 1731 Northwest 44th Street in Miami.
Se alega, señor, que este delito ocurrió el 25 de septiembre del 2025 en la vecindad del 1731 del noroeste, 44 calle en Miami.
Okay, so I've appointed the public defender's office to represent you. I'm going to take a look at both of these arrest affidavits. There is a proposed stay away order supposedly in the 22120 case, which is the alleged victim is a Juan Diaz. Okay, and they did file a motion.
Entonces, señor, le asigno al abogado de oficio para que les represente. Voy a proceder a la lectura de ambos informes de arresto y además se me solicitan aquí órdenes de alejamiento. En el caso que termine en 2120, la presunta víctima lleva el nombre de Juan Díaz. Ellos presentaron una moción
For pretrial detention in this case.
para que se haga una moción de retención previa a juicio sin fianza.
Okay, in case number 20, the one ending in 2099, the alleged victim is Sunil Banda.
En el caso que termine en 2099, tenemos presunta víctima llamada Sunil Banda.
And there's also a motion for pretrial detention requesting to be held no bond.
Y también se ha presentado una solicitud o moción de que se les retenga para audiencia previa a juicio sin fianza.
And finally, the corrections has advised that you do have an immigration hold.
Y por último, correccionales o penitenciarios nos ha informado de que usted tiene una retención por parte de las autoridades migratorias.
All right, so I'm going to take a look at the A form and then discuss your bond status.
Ahora voy a proceder a la lectura de los informes de arresto y después hablaremos acerca de su fianza.
Okay. All right, there's probable cause on both of these cases.
Tenemos motivo fundado para ambos casos.
I'm setting no bond on both cases, both counts.
Establezco no fianza en ambos casos, en ambas acusaciones.
There's a motion that has been filed for pretrial detention that needs to be addressed at a future hearing. However, I'm holding no bond. There is also an immigration hold and there's a stay away order. Sir, if you are able to post bond or be released at any point in time, one of the conditions for your release is that you not have any contact, direct or indirect, with the alleged victims in this case.
Muy bien, entonces aquí tenemos mociones para que se les retenga previo a juicio en ambos casos y además tenemos una retención por parte de las autoridades migratorias. Yo le estoy reteniendo sin fianza en ambos casos y tenemos órdenes de alejamiento. El señor C le indica que si usted llegase a poder pagar fianza y por alguna razón pudiera pagar la fianza y salir, usted no puede tener ningún tipo de contacto con las víctimas en estos casos, ni de forma directa, ni indirecta, ni a través de terceras partes.
Have to stay at least 500 feet away from them, their home, their place of employment, or school at all times. Do you understand?
Usted tiene que en todo momento estar como mínimo 500 pies alejados de estas personas, el lugar donde ellos viven, el centro de trabajo donde trabajen, escuela a la que asistan, donde quiera que ellos se encuentren. ¿Usted comprende?
All right, good luck.
Yes. Buena suerte, señor.
Roberto Pinal. Mr. Pinal is present. He speaks English. He speaks English? Yes. Okay. All right. Good morning, Mr. Pinal. You are before the court, and I've appointed the public defender's office for the purpose of this hearing. It's alleged that you committed the following offenses. One count of burglary with assault and battery therein. One count of criminal mischief, $1,000 or more. And one count of criminal mischief, more than $200, but less than $1,000. And this supposedly took place on September 21st, 2025 in the vicinity of 1628 Southwest 6th Street, number 4 in Miami. I'm going to take a look at the arrest affidavit and read it to see if it has probable cause for the offenses as charged. If you are, there's a motion that has been filed by the state with regards to count 1 of the charges, the armed burglary, for pretrial detention that needs to hold you no bond. I mean, it's charged as a punishable by life. So, but that is, and there's proposed stay away order that if you are able to post bond or be released under whatever conditions, you cannot have any contact, direct or indirect, with the alleged victim in the case, who is Marianela Luna. Okay, that means no contact direct, in writing, by phone, through social media, or through third persons. You would have to stay at least 500 feet away from victim's home, place of employment, or school at all times. Do you understand? Okay, so let me read the A form. All right, any argument?
Yes, Judge, I would ask you to find no probable cause for burglary with an assault or a battery. The alleged victim responded to him when he made a comment, "I want to smack you." And she said, "I wish you would." So that appears to be an invitation, Judge. And an invitation for mutual combat at a minimum. Certainly is not a case that would be punishable by life in prison when someone's making a comment back to the judge. I think we have to put this in perspective of what this is.
I disagree with counsel. I think there is probable cause.
And Judge, with regard to the criminal mischief, is charged with $1,000 or more. For the car itself, it's an approximate repair value of $1,000. It does not appear they got an estimate. It's an approximate. So I would ask you to find probable cause for a first-degree misdemeanor. And for the iPad, it does not indicate who the owner is. They're saying it's their child's iPad, so he's the parent of the child. Judge, it would just be as much as his as the child's. I would ask set a bond, Mr. Pinnell, Judge.
All right, I've read the arrest affidavit. I've listened to argument of counsel. The court finds that there's probable causes to count one. Okay, so he's going to be held no bond on count one.
Judge, with regard to the bond, even if it's a battery, Judge, a battery sitting in or out of a car, it's the same level of dangerousness, Judge. I would ask that you not require him to sit all weekend long. He's a father of 2 kids. He does pay child support. He's lived in the community all of his life. He works in a warehouse, loading trucks for an oil company, Judge. So he is working. He is supporting his family. At best, this is smacking somebody, Judge. That's certainly not something that other people come before the court with much more egregious allegations, and they are granted a bond every day. And he's accused of smacking her. I would ask that you set a bond commensurate with the allegation, Judge. A battery bond is typically $1,000. If Your Honor,
I've already
increase it, I would just ask that you consider setting a bond for him, Judge. The only thing that's different is that the allegation she's sitting in a car versus standing outside the car. That's the only thing that's different, Judge. And this is somebody that
I respectfully disagree with you, and perhaps you can bring it up at the conference hearing. I am going to set no bond. I find that there's probable cause. Count 2, 2,500, count 3 years, no PC, ROR on that one, release outright. Okay, there's a stay away order that the court is entering. One of the other conditions, sir, is that you cannot engage in any criminal activity. You cannot use or possess any illegal drugs. And if you own a weapon, ammunition, or any kind of firearms, you have to surrender them or permits to the nearest police department if and when you are released, and file a receipt with the court. Let's see. Good luck, sir. Next case is, let's see here. Xavier. Is this Mr. Cal? Morning. All right, Mr. Cal, you're before the court, alleging that you committed the offense of petty theft, 2 or more convictions, which makes it a felony. Alleged victim, CVS Pharmacy, located at 690 Northwest 57th Avenue. I've appointed the public defender's office to represent you in this hearing. Just take a look at the A form. Said $2,500 bond.
Judge, would you consider the TAP program for Mr. Cal? He is currently homeless. Judge, he's okay with the bond. Thank you.
And a stay waiver. You can't go anywhere near the CVS. Mr. Cal, understand that? The one located at 690 Northwest 57th Avenue.
Stray bond.
Stray bond. Thomas Cesare. Mr. Cesare, good morning, sir. It's alleged you committed one count of possession of crack cocaine, suspect crack cocaine on October 9th, in the vicinity of 21600 South Dixie Highway. Does he have anything open?
No.
He just, in September
It's a 25-day
1st,
sentence.
was just
Yeah.
convicted for the same thing. Actually, 24th.
Judge, would you consider TAP for Mr. Cesare? He's apparently never received TAP. He would like to get treatment if he could.
I mean, any objection? I mean, it's not violent, but he has a record.
The issue, Judge, he has a conviction from just
He
a few
just
weeks ago.
got out, pretty much.
Well, but if you get out and there's no treatment, what do we expect?
Okay, but
And that's why I'm asking.
I get it, but the court also is considered, has to consider the safety of the community.
There's nothing that happened to the community in this case. Judge.
Okay.
So if anything, it would be assisting him to help prevent this from happening in the future. But if he never gets TAP, he never gets treatment, it makes things challenging. What do we
Is there
expect?
any way of knowing if he's ever been referred to TAP? State? Because it's,
The TAP program would have records. I mean, I'm sure at some point he must have been.
I find, to me, with contacts this consistent, I'm sure that was, look, it's clear, the majority of the contacts are drug related, no question about it. Of course, the issue the court is having is a couple of days ago, he just completed 25 days, the same, and he's now back. Will TAP take him? He's homeless? Is there anybody eating from TAP? Oh, she's stuck. What's the return date on TAP? Is that the what I have here hanging there? So it's the return date is November the 10th, is what it says. And where does he report to? If I give him the instructions?
They'll meet with him personally, Judge.
No, I have to. Huh?
Oh, you mean what courtroom? It's
Is it
Judge
David?
David Young. It's on the 7th floor.
Okay. 7-3. Courtroom 7-3. All right. Okay, this is what I'm going to do. Mr. Cesare, I'm going to refer you to the TAP program. Okay. You will, and I'm finding probable cause as charged. So would have been a $2,500 bond. So I'm going to refer you to this program. I suspect you've been there before, but let's give it another try. You are, this case will be back here in court on November the 10th, 2025, and you're supposed to report, that's the date to courtroom. I'm being told 730 before Judge Young. Is he gonna get some type of documentation?
I'm gonna give it to him right now, Judge.
Okay.
Okay.
All right. Next case is Ronoy Smith.
Your Honor, before we go to Mr. Smith, for Mr. Pennell, the third count, criminal mischief, you found no PC, was that released?
Release outright, yes.
Okay, thank you.
Pardon me? Didn't find PC on them. Release, just make it. For them, then here, let me. Because usually it's release. You have to write release outright. There you go. That's what it is. Okay. All right, is this Mr. Smith? All right, Mr. Smith, good morning, sir. You're here before the court because it's alleged that you committed the offense of burglary of an unoccupied structure or conveyance on October the 8th in the vicinity of 3787 Thomas Avenue in Miami. And the alleged victim is a person by the name of Karina Leipzig. Okay, so there's a potential stay away order that any conditions of your release will include that you not have any contact with this person, stay at least 500 feet away from this person, and you not go near the address of 3787 Thomas Avenue. You understand? Yes? Okay. Let me take a look at the arrest affidavit and to determine your bond status, sir. When was he released? State for the, if you have that information on the.
I can get that information. 1 second.
Says he's on, is he on probation?
He was released from prison in January of 2030.
Okay.
So this should be
Huh?
burglary to a dwelling, second-degree felony, requesting a bond.
Yep. But he's not on probation, right?
No.
Okay. Because it was followed up, it looks like by 1 year probation, but it looks like it was terminated just. Yeah. 2024.
So Judge, I would ask you to find no prejudice in this case. He's charged with an enhancement of prejudice. Mr. Smith receives Social Security disability income. He has a nerve condition and he is about to be placed on a walker by his doctor for his medical condition, Judge. He does not have funds for a bond. Would Your Honor consider house arrest for him with the ability to his medical appointments?
I'll consider, I find probably, I'll consider reducing on $5,000 and stay with him. Did prison term not long ago for the same thing. Raymond, yes. Burgess? Are you Mr. Burgess?
Well,
Okay, good morning. Mr. Burgess, you're before the court because it's alleged that you committed one count of grand theft of a dwelling or curtilage on October 9th in an apartment complex located at 680 Miller Drive, number W102 in Miami Springs. Okay, I've appointed the public defender's office to represent you. I'm going to take a look at your arrest affidavit and all the other information to determine your bond status, sir. Any arguments?
Yes, Judge, there's no value of the package. Looks like it would be theft.
It may be from the cartilage though, because it was on the porch or in front of the door.
But she's arguing it's to lack of value for the grand theft.
Right, but potentially it's a burglary or a theft from the dwelling. Would your honor find PC maybe just on the petty theft, but increase the bond? State's requesting no less than 1,000. The defendant's got a conviction from August, 23 days in jail.
Yeah, saw that.
Judge, Mr. Burgess is currently homeless, does not have funds for a bond. Would you consider tap?
No. I mean, I find probable causes to petty theft. The court is going to increase the bond. Consider his priors, same committed offenses, and most recently, it looks like he just completed a imprisonment term, albeit for the last one was for possession of cocaine in August of this year. I'm going to set bond at $1,000 with a stay away order. Page 6, Lamar Milburn. Are you Mr. Milburn?
Yes.
Okay, good morning. It's still morning. All right, sir, you're before the court because it's alleged that you committed on October 9th at the Marshalls located in North Miami Beach at 900 North Miami Boulevard. One count of battery on a law enforcement officer, correctional officer, firefighter, and 6 counts of petty theft with previous conviction. I've appointed a public defender's officer for purposes of this hearing, and I'm going to take a look at the arrest affidavit. And I see that you just close out some cases on something related on June of this year. Yeah. Okay, let me take a look at this.
So then there'd be probable cause on count 1 and count 2. ROR the rest. Count 2 would be a 3rd-degree felony.
Defense? So Judge, with regard to count one, looks like he's told to remove his socks. So it may be an issue of communication whether or not he thought the officer wanted the socks from him after he took them off. So it doesn't look like there's any like intent to harm or anything like that. They said he threw the socks to the officer.
It says intentionally threw them at me, striking me in the right side of the face and chest. There's probable cause.
But if he's being asked to take them off, then if
But you don't throw them at the officer's face, you take them off your feet.
So Judge, the arrest was not clear.
All right, I'm finding probable cause.
Consider pretrial services, Judge.
The battery on the first count, I'm setting that $5,000 on count two.
Consider any decrease in the bond, Judge.
No, not with his priors.
Is petty theft
prior that in the second count.
They're petty theft priors, Judge.
I understand that. They enhance to felonies after a certain amount.
Well, I understand, but I'm talking about count one,
Okay,
Judge.
let me know
The battery.
I'm making my ruling, okay? Count one, probable cause, I'm setting bond at $5,000. Count two, I'm setting bond at $2,500. And on counts 3, 4, 5, 6, and 7, release outright. With a stay away order. He cannot have any contact, direct or indirect, can't go anywhere near the marshals located at 900 North Miami Boulevard in North Miami. Good luck, sir. Next case is Johnny Hancock. Mr. Hancock, good morning, sir. You're charged with 1 count of petty theft, 2 or more convictions, which makes it a felony, and 1 count resisting an officer without violence to his person, a misdemeanor. This allegedly took place on August 7th of 2024, is what it says here, at 1601 Northeast 164th Street, which is Miami Beach, North Miami Beach Library. In North Miami Beach. I've appointed the public defender's office to represent you. I'm going to take a look now at the arrest affidavit to determine your bond status, sir. Okay? Where's the information on the previous conviction?
It's not there, Judge. So it would be a petty theft resisting without.
I would ask if you would consider pretrial services for Mr. Hancock, Judge. Looks like he was bothered with the police.
Where do you live, sir?
North Miami Beach, ma'am.
Do you have an address?
Yes, ma'am.
What's your address?
411 Northeast 167th Street.
411 or 211?
No, it's 411 162nd Street, North Miami Avenue.
I think the last contact he had 366 days in 2020, correct?
Yes, ma'am.
The A form says 211, that's why I asked you, Northeast 162nd Street. So you sure that that's?
Right, it was 411.
All right, I'm going to, terms of, count one, that's a mystery. The probable cause is only as to that because the A form is lacking. And then there's probable cause for count two. So what I'm gonna do is I'm gonna refer to pretrial services. Okay, with a stay order. Alternate bond in count one, $250, count two, $500.
What was count one again?
Pardon me?
I didn't hear count one, Judge.
250.
Got it. It was 250 and 500.
And no contact, can't go anywhere near the library, understand it? Okay. Garrett Allen. See. Mr. Allen, morning. Okay, you have two cases before the court. The first one is F25-22095, and that alleges you committed one count of strong arm robbery, one count of criminal mischief of $1,000 or more, which makes it a felony, and one count of simple battery, first degree misdemeanor. The alleged victim in that case is a person by the name of initials DL. Okay, so any conditions of release or any release would require, I'm telling you ahead of time, that you're going to be prohibited from having any contact, direct or indirect, with this alleged victim. Neither direct or indirect contact, okay, in writing, through person, by phone, by pager, or fax. You understand that? You have to stay at least 500 feet away from this person, their home, their place of employment, or school at all times. Understood? Okay. The other case, which is F25-22105, it's alleged that you committed the offense of driving while license suspended, 3 or more subsequent convictions, which makes it a felony in the 3rd degree. This occurred on October 9th, yesterday, in the vicinity of 1545 Northwest 41st Street. Okay? Understood. All right, I've appointed the public defender's office to represent you, so I'm going to take a look at both of these A forms and determine your bond status. Any argument on the 2095 case?
Yes, Judge. On the criminal mischief, it just states that the phone was shattered. It has the value of the phone at 1,000, but it doesn't say what the repair amount is, Judge. That's usually like $100 to replace a screen, the glass screen, Judge. So I can't imagine it'll be $1,000. So I'd ask you to bring probable cause for misdemeanor, criminal mischief, or count 2. Okay. All right. Okay, as to case number ending in 2095. The court agrees with regards to the criminal mischief as to count 2 with the defense. So I'm setting bond on count 1 at $7,500. Count 2, $250. And count 3, I'm reducing that to another $250 with a stay with
250?
250, yes. 7,500 first count, and then 250 count 2, 250 count 3 with a stay with.
Corrections, do you have any kind of holds?
I'm sorry?
No, I don't have
okay.
anything on the card.
I think he's on supervised release.
He is on supervised?
Yes, but the Florida Department of Offenders would have to place a hold, which they haven't done yet.
Okay, as to count, as to the case number, the other one, which is the the end one ending in 2105.
On that case, Judge, I would ask you for a probable cause for misdemeanor driving while license suspended. There's nothing indicating he has any prior convictions. Just that he has
Under following cases, it says it there has been previously suspended in case number 1, 2.
It doesn't say conviction.
Oh,
you have to have the convictions. So
and
that's
they, no, I know, but those are those have not been closed out.
it just says that there's suspension, so there might just be administrative suspension.
It might.
Yeah, there's nothing indicating any kind of conviction.
So what's the bond on driving suspended?
I think it would be 500.
That's what it is. Yes, $500.
Straight bond, 500.
Straight bond, yes, 500. WLS. She's putting little stars here so I can see. Gary Allen. Oh, this is what we just did. I'm sorry.
Your Honor, if we
Next,
can, Mr. Thompson,
Luis Scott. What?
Robert Thompson,
Oh,
if you take him out of number 30.
We're not using. We use the other one. We made 2 duplicates, like the same one before. Okay, calling out of turn, page 9. Robert Thompson.
And this is another charge. He came in on an assault. He received the bond, misdemeanor assault bond of $250.
Okay. Is this you're Mr. Thompson?
How you doing, man?
Fine, thank you. Mr. Thompson, you're here because it's alleged you committed the offense of grand theft in the 3rd degree on September 23rd. I appointed the public defender's office to represent you. Let me just take a look at your A form on this. Let me see. Where's the value on this?
So it's a scooter, it's a motor vehicle, so per se.
This is a scooter?
It doesn't indicate motorized.
It just says victim's
Right.
scooter. He left scene leaving the dock with a scooter.
I mean, if it's not motorized, it would be a petty theft, but maybe increase the bond because the defendant was just sentenced to 455 days 2 months ago.
I'm sorry, I didn't hear what you said.
So fine PC for petty theft for the scooter because it's unclear whether or not it was motorized, but increase the bond because he was just sentenced to 455 days earlier, about 2 months ago.
That was for what, an L&L? It looks like.
So that was right. It looks like he just completed a jail sentence. He's got a conviction for battery on a detainee from August, as well as L&L exhibition at a correctional facility.
I'm setting bond 1,000. 1,000, 1,000. Back on the calendar, Luis Caballero. This is on page 6. Come on. Luis Caballero. Spanish for Mr. Caballero, please. All right, Mr. Caballero.
Yes, señor.
All right. Good morning still. All right, Mr. Caballero, you're here because it's alleged you committed 1 count of possession of cocaine as an offense and 1 count of tampering with physical evidence or attempt thereto.
Muy bien, señor Caballero, buenos días. Usted está acá porque se alega usted cometió los siguientes delitos por haber estado en tenencia de cocaína y además por haber intentado modificar o alterar pruebas físicas o al menos intentarlo.
Does he has other cases that he
There's
has
an
pending hearings, right?
an open trespass.
Pregunta a su señoría a la fiscalía si usted tiene algún otro caso pendiente. Indica a la fiscalía que tiene por resolver todavía un caso de entrada sin permiso.
Is he out on some type of release?
¿Estaba él fuera bajo algún tipo de liberación?
I don't know how he was released on that misdemeanor.
Has it looked
I
like
don't have anything else on the card, you know, in this case.
he has nothing else?
No.
Oh, because it shows that he's got a hearing pending October 15th in B25-21247 for trespass after warning.
There must just be an open case he's not in custody on.
Okay.
Entonces se esclarece por parte de correccionales que ese caso de entrada sin permiso quizás es un caso que usted todavía tiene por resolver, pero el cual no le tenía retenido en detención, y hace constar su señoría que usted tiene en el sistema una audiencia próxima ahora el 15 de octubre para dicho caso.
Where do you live?
¿Dónde vive usted?
Yo iba en la 41.
Señor, discúlpeme, esta es la intérprete. Necesito que se exprese directamente al micrófono y en voz alta.
4111, no voy a 37 Street. Pero ya todo eso lo voy a perder, ya todo eso lo perdió. Pero me voy a quedar en la calle ahora.
Well, I be left on the street homeless very soon or now already happening, but I was living at 4111 Northwest 37th Street.
Have you ever lived at 7179 Southwest 21st Street?
No.
Señor, ¿y usted alguna vez ha vivido en el 7179 del suroeste 21 calle?
Sí, pero yo me fui ahí.
Yes, but I left that place.
I mean,
Tiene
he's got a trespass and his last contacts were, oh, wait a minute, there's one here resisting in April. Okay. And petty thefts. Okay. Never mind.
Entonces aquí vemos en el historial que justo de abril datan algunos casos de hurto en menor cuantía, también entradas sin permiso, pero continúo leyendo. No, no importa.
Would you consider tap, Judge, Mr. Caballero?
Pide la defensa que por favor consideren el programa TAP.
They can help to find Michelle for them.
Ellos pueden ayudarle a hallar, un momento, señor. Ellos pueden ayudarle a hallar algún tipo de albergue.
Yeah.
All right.
Y luego, si no, que me deje el tiempecito.
Sure. All right, I'm gonna refer him to the TAP program. An alternate bond, I don't know if they need it. I'm gonna set bond in each of these counts at 1,000 each, 1,000, 1,000. Sir, it's important for you to understand, because it sounds to me like you're telling me you may not have a residence. You need to report back to court. I think we said on November 10th. Okay, so I'm giving you oral notice, okay? You may get something else in writing, but I'm giving you oral notice on November 10th. In the morning, 9 a.m., you need to be, I believe they said courtroom 730 in front of Judge Young here in the
No, this is gonna be
Rodriguez?
Ariel Rodriguez.
Okay, but it's courtroom 7-0, right?
No. It'll be
I
a different
gave-
court. I'm not sure which one is Judge Rodriguez's courtroom.
272? 27.
27.
Okay, there we go. So courtroom 27 on November 10th, 2025 at 9 a.m. Got it?
Muy bien, señor. Entonces le vamos a dejar salir con supervisión del programa TAP. Estoy poniendo alternativamente la fianza en el cargo número 1 de $1,000, en el cargo número 2 de $1,000. Pero como usted me está indicando que está muy próximo a quedarse sin hogar, le estoy dejando saber ahora, le estoy dando notificación oral de que el día 10 de noviembre a las 9 de la mañana usted tiene que estar de cuerpo presente en la sala 27 del edificio penal de justicia de la Corte Criminal ante el juez Ariel Rodríguez. 27 el día 10 de noviembre a las 9 de la mañana.
Page 7. Did we do that? I didn't mark it. This one? Is that? Okay. Well, didn't even pay- okay, all right, well, that's right. You're absolutely right. Okay, Lester Telles. Is that Mr. Telles?
No, that should be a bond out.
Is it a bondo?
Corrections, number 23, bond out?
Telles?
Yes? Yes.
Yes, I'm gonna make a note here. Thank you. Next one is Dwight Dennis. Are you Mr. Dennis?
Yes, ma'am.
Okay, morning, sir. You're before the court because it's alleged that you committed the offense of possession of crack cocaine and possession of drug paraphernalia yesterday in the vicinity of Northwest 30th Avenue and 52nd Street in Miami. I've appointed the public defender's office to represent you. Let me take a look at the A form and address your bond status. Let's see what you got here. It looks like the last contact he had was like in 211.
So pre-trial's good.
Okay, well, will they or tap? Which one? Pre-trial? Okay.
Tap, please. With a future court date.
Okay, what's your address? Where do you live?
He's homeless, Judge, if you can get him a future court date, please.
Okay. TAP doesn't need an alternate bond, do they?
They
Yes.
do.
Oh, they do?
Okay, it does.
All right. All right. I'm gonna set, okay, so TAP program, alternate bond number 1, count 1, it will be 500, count 2, 100. Okay, I'm gonna be instructing you, sir, that you need to return to court. I'm giving you oral notice. You may get something in writing, but I'm giving it to you so that you should not, if you fail to appear, you may get picked up. So you need to report back to court at the Criminal Justice Building on November 10th in courtroom 27. That's what we said, right?
7-2.
Oh, this one's different, so they're all different.
They're all different.
Oh, okay, well, there we go. I didn't know that. Okay, so on November the 10th, 2:20 of this year on courtroom 7-2 in the morning on AM. Okay. Reginald Brooks. Is this Mr. Brooks?
No.
Yes, Mr. Brooks, you're charged. It looks like they were claiming you committed the offense of possession of suspect oxycodone, controlled substance, a third-degree felony, on October 9th at the Kent Hotel located at 1131 Collins Avenue. Is this the first contact with the system?
So he's from Houston, Texas.
Houston. Okay, I just saw that. Okay.
But there's some prior arrests out of state.
Yeah. Let me just see it. $2,500 bond. Eric Miles.
Judge, Mr. Brooks cannot afford a $2,500 bond. He thinks he can afford about $200 to $250. Would Your Honor,
Standard bond.
any sort of reduction?
Not from my reading in that A form. Eric Miles. Mr. Miles, good afternoon, good morning. You're before the court. It's alleged that you committed the offense of grand theft in the third degree from Home Depot on June 6th of this year. And that's the Home Depot located at 19400 Southwest 106th Avenue. Sir, any conditions of release require you not to stay away from the Home Depot. Can't go anywhere near that place. Do you understand that? Setting standard bond at 20.
This is a delayed arrest. Would Your Honor consider pretrial services for Mr. Miles?
I was, but then you look at his priors, this gentleman basically completed, let's see here, this year. There was activity already in April this year, 35 days. He's had consistent contacts with the system, so it's straight bond 2,500 with a stay away order. Lucas Vera. Mr. Vera, do you speak English?
I do.
Okay. Good morning. We're here before the court, sir, because it's alleged that on October the 3rd of this year, in the vicinity of 10825 West 50th Street in Doral, you committed the following offenses. One count of threats or extortion threats and one count of unlawful use of a communications device, both of which are felonies in different degrees. I have appointed the public defender's office to represent you. I'm going to take a look at the arrest affidavit. They are requesting the state that I enter a stay away order, irrespective of whatever type of release. That one of the conditions is that you not have any contact, direct or indirect, with the alleged victim of the case whose initials are RT. That means no direct or indirect, no in person, in writing, by pager, phone, third persons. You have to stay at least 500 feet away from that person's home, place of employment, or school at all times. Do you understand that? Yes? Okay. Let me take a look at the arrest affidavit to address your bond. And it looks like this is a first contact with the system.
But they're very serious allegations.
Okay, I haven't looked at the A form. You guys have the benefit of this. I don't. All right. Any argument?
No, Judge.
Okay. Setting bond on count 1 at 7,500, count 2 at 2,500 with a stay away order, which has been read to the defendant. Good luck, sir. Jermaine Jean-Francois.
Bond out.
Okay. Benjamin Mitchell, we're on page 9. This was a refusal previously.
He's
He's here. Okay. Mr. Mitchell. Good morning. All right, sir, you're here before the court because it's alleged that you committed the offense of petty theft with 2 more convictions on October 8th. In the vicinity of 17460 Northwest 57th Avenue, which is the Lowe's. Okay, I have appointed the public defender's office to represent you. I'm going to take a look at the arrest affidavit to determine your bond status, but any conditions of release will include a stay away order. If you are able to post bond or release otherwise, you can't go anywhere near this Lowe's that I just gave you the address. You understood? Okay, take a look at the account. Okay. There's probable cause, setting bond at $2,500 with a stay away.
Judge, would you consider the tap program for
No.
Mr. Mitchell? He's currently homeless and does not have funds for a bond. He's never received cap.
No. Outright bond, 500. Next case is Ronald Roque. Reyes.
This is an added charge and he has a hold for immigration.
Okay.
Spanish, please.
Okay, good morning, Mr.
Present.
Reyes Roque.
Buenos días, señor Reyes.
You are before the court because it's alleged, sir, that you have committed the offense of retail theft, more than $750 at multiple locations. Specifically, we're talking about Burlington, located at 11919 Southwest 88th Street in Miami.
Muy bien, señor. Buenos días. Usted está aquí presente por un caso donde se alega que usted cometió hurto en menor cuantía en tiendas por un monto de aproximadamente $750 o más en múltiples lugares. Específicamente nos referimos al 11919 del suroeste 88 calle, tienda Burlington.
All right, and this incident supposedly took place on September 30th of 2025.
Supuestamente este incidente tuvo lugar el 30 de septiembre del 2025.
I've appointed the Public Defender's Office to represent you for this hearing, and now I'm going to be taking a look at the documents to address your bond status.
En estos momentos voy a echar un vistazo al informe de arresto. Ya le he asignado el abogado de oficio. Por favor, permítame para poder determinar el motivo fundado.
Any argument?
¿Alegatos?
No.
No,
Standard
su
bond,
señoría.
$2,500, and a stay away order.
Tenemos fianza entonces estándar 2.500 y orden de alejamiento.
All right, I also, I don't know if I said it, but I was advised that you have an immigration hold, sir. Okay.
No sé si ya se lo había mencionado, pero se me informa de que usted tiene una retención por parte de las autoridades migratorias, señor.
Good luck. All right.
Buena suerte.
On page 10, Darius Robinson. Oh. Mr. Robinson?
Yeah.
All right. Good morning, sir. You're here before the court because it's alleged that you committed the following offenses: one count of possession, with possession of cocaine within 1,000 feet of a church, and or convenience store, and one count of, it looks like, open container of alcohol near a store in violation of the county ordinance. And this totally took place in the vicinity of 17585 Homestead Avenue. I've appointed the Public Defender's Office to represent you. I'll take a look at the arrest affidavit to address your bond status, sir. So Judge, with regard to probable cause, there should be no enhancement. It should just
I
be a
agree.
possession of cocaine. State agrees?
Yes.
And Judge, I would ask if you would consider the TAP program for Mr. Robinson. He is currently homeless and could utilize the services of. He just served 18 months, a couple of months ago.
And then 60 days
on
in April.
All right, count one, reduced possession cocaine, 2,500, count two, $150, straight bond. Dennis Pena? Or Pena? Is that, do you speak English, sir?
Yeah.
Okay. All right. Okay, sir, you're here before the court because it's alleged you committed the offense of possession of crack cocaine yesterday in the vicinity of Northwest 46th Street and 23rd Avenue. I appointed the public defender's office to represent you. Let's see, let's take a look at this. Last contact was 2010.
The pretrial is good.
Where do you live?
344 Southwest 18th Terrace, Miami, Florida.
How long have you lived there?
30 years.
All right, I'm going to refer you to pretrial services, and alternate bond $2,500. Count one, okay?
Oh, okay. Thank
Make
you.
sure you come to court, sir. Lamont man. Is this Mr. Mann?
Yes.
All right, it looks like he has an open misdemeanor. A bound down, B254759. Or is it closed?
That was null process, Judge.
Oh, no process.
Yes.
So this is the only thing he has.
Yes.
All right, Mr. Mann, you're before the court. It's alleged that on October 9th at the Publix located at 9510 Southwest 160th Street, you committed the following offenses: 1 count of aggravated battery, which is a second-degree felony, 1 count of criminal mischief, $200 or less, and 1 count of disorderly conduct or breach of the peace, also second-degree misdemeanor. I've appointed the public defender's office to represent you. Let me take a look at the arrest affidavit. The alleged victim is a person by the name of Alexis Harden, who apparently was at this Publix. Any conditions of release, either today or in the future, will require you, I'm telling you, to stay at least 500 feet away from this person and stay away from this Publix. You cannot have any contact with this Alexis Harden. Are you listening? Okay. Either directly or indirectly. That means no contact in person, in writing, by phone, by pager, or fax, or third persons. Also, no electronic contact, no emailing, texting, Facebook messages, or Twitter. Understood?
Yes, ma'am.
Yes? Okay, so let me take a look at the safe one. All right. Any argument?
Judge, I don't see any probable cause for any criminal mischief.
It looks like, oh, they're in front of the store throwing things.
Throwing plates, it says, or other items, but I agree with
Okay.
the defense.
Judge, would you set a total bond of 5,000?
Count 1, $5,000. Count 2, release outright. Count 3, $150. With a stay away order. Sir, don't go back to that place. If you're able to post a bond, don't come near this Alexis. Okay, good luck. Next case is Eloy Fernandez.
He's on felony bound.
He's out on hold. Okay. Oh, yes. Case number F25177753. There's gonna be hold on that.
Yes, Your Honor.
Mr. Fabus, speak Spanish or English?
Spanish.
Okay. Madam
Present.
Interpreter? Let Mr. Fabulous know that he will have a hold in case number F251775 because he's out on felony bond in that case.
Muy bien, señor Febles, buen día. Usted va a tener una retención por delito mayor en el caso F2517753 porque usted estaba fuera bajo fianza por delito mayor.
Okay, today you're before the court because it's alleged that you committed the offense of possession of crystal meth, which is a controlled substance, of third-degree felony.
Usted está ante este tribunal el día de hoy porque se alega que usted cometió el delito de haber estado en tenencia de cristales de metanfetamina, que es una sustancia regulada, y esto es un delito mayor en tercer grado.
Okay, I've appointed the public defender's office to represent him in this case, or at least for this hearing. And I'm now
Yes.
going to look at the arrest affidavit to determine his bond status.
Le asigno el abogado de oficio para que le represente al menos por esta audiencia y en estos momentos voy a proceder a la lectura del informe de arresto para poder determinar el motivo fundado.
Any argument?
¿Alegatos?
All right, I find probable cause as to count one, set standard bond at $2,500. Straight bond.
Muy bien, determina el motivo fundado y voy a imponer fianza directamente de $2,500.
Next case is Darren Smith.
Ward D.
Let me take a look at this. PC's already been found, so when do you want to reset this for?
The afternoon?
I'm sorry?
The afternoon?
PM?
Yes.
Okay. James Foley?
Ward D.
We can reset it for the afternoon.
Yes, we're doing this here. I think I can close the calendar. Okay, when do you want to come back, everyone?
Can we start at, Your Honor? At 1 o'clock?
It's fine with me. How about you, Madam PD?
You could
I'm fine
try.
with me.
Can we try? Okay, the clerk is telling me they can't guarantee. They have a lot of paperwork.
Okay,
Large, but we can try.
we'll try. Thank you.
Either one. All right, terrific. Thank you for all your help.
Thank you.
Thank you, Your Honor.
Recording stopped.
So we're starting at 1.
limited. Yeah, but I'm here. Let's do those more often than not. I get Mondays off. There you go. Which everybody gets it. What if I just say, yeah, I'll come in. Come in and walk out. Did you go in? And then all my. Let's make rules just to make rules. We'll figure that out after. The keys kind of simple. Yeah, you know, quick job. Impossible. Impossible. But they get. Yeah. Would love to be done. Yes. Juveniles. 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 And still have experts that on top of one of the court's desks, coach all of her stuff. Oh yeah, it's not 100%. It was living half of it, and I think he wasn't functioning, the other half, he wasn't. There's still troubleshooting to do. There's still troubleshooting to do. What's not? Just this part. Oh, doing this. You may not need this. So many of them. I hope so. I hope it's a page. So, our approaches was telling me they didn't have a lot of people. They're expecting. I'm not. They told me there wasn't a lot of people in the lobby, but they have accurate with their predictions before.
If it's a small calendar, no, but if it's big, I'll.
No, very polite. I don't try to speak over others, and it's difficult to find that.
No,
And yeah, I'm academic.
I know that you have to do that. All right. See you here.
This corner is so small. It looks bigger on TV.
Yeah.
This is the one where all the action happens, right? With Judge Glazer. Cool. Have a good day.
Recording in progress.
Good afternoon, everybody. All rise. Right hand.
Buenas tardes a todos. Pónganse de pie y levanten sus manos derechas.
Good afternoon. Do you swear or affirm the testimony you are about to give to be the truth, the whole truth, and nothing but the truth? So say I do.
Buenas tardes. ¿Juran que dirán la verdad, toda la verdad y solamente la verdad?
Sir interpreter, have you been sworn in today?
Yes.
Okay. Okay, all right. Good afternoon, everyone. You may have a seat. I'm Judge Dennis. I'll be presiding over the first appearance hearings this afternoon. All of you have heard a videotape played in English, Spanish, and Creole. For purposes of this first appearance hearing, I will be appointing the Public Defender's Office for each of you for the limited purpose of this hearing, unless the court finds that you don't qualify through separate inquiry or unless you have a privately retained counsel. I would like the attorneys of record to please state their names.
Muy buenas tardes a todos. Soy la jueza Espinosa Denis. Voy a presidir sobre las primeras comparecencias del día de hoy. En todos los casos, yo pienso que ya vieron el video que se les puso en creol, en inglés y en español sobre este tipo de audiencias. Tengan presentes que en cada caso les voy a nombrar a los abogados de la Defensoría Pública para que los representen, a menos que ya tengan abogado o a menos que se deduzca después de hacerle preguntas que no califican para esos servicios. Abogados, preséntense.
Madam State.
Nessa F on behalf of the state.
Thank you.
Sydney Goss, Assistant Public Defender.
Okay. Ms. Corey, you're not going to make an appearance?
Rebecca, Assistant Public Defender. I'll be here too.
I'm sure you'll have something to say. Okay. All right. Good afternoon to everyone. All right. Is there anything that corrections needs to be called out of turn before we get started? I know the clerk was making inquiry about that. No?
No, Your Honor.
All right. Terrific. Okay. First case on the calendar is Tina Schofield.
Your Honor, she court. Second refusal.
I'm hearing you.
Correction, she refused again.
Oh, again?
Yes, refuse court, second refusal.
Okay.
So if we can reset it for tomorrow, please.
All right. In the morning?
Yes.
All right, reset. October 11th in the AM. Next case is Johanna Hune. In the box with me. Are you Miss Hune?
Yes.
Okay. All right. All right, Ms. Kuhn, I have an arrest affidavit here that says that it is alleged that you committed the following offenses on July 16, 2025 in the vicinity of 22357 Southwest 119th Avenue in Miami. The first offense is burglary with an assault and battery therein, which is a first-degree felony, aggravated battery, 1 count, second-degree felony, and strong arm robbery, second-degree felony, 1 count. As I stated earlier, I've appointed the Public Defender's Office to represent you, so now I'm going to be taking a look at the arrest affidavit to address your bond status, in addition to which the state of Florida has also filed a motion for pretrial detention pursuant to Florida Statute 907.041(5)D, and there is a proposed stay-away order so that if you are released today or any other day or any form of release, you will be subject to a stay-away order, which means that you will be prohibited from having any contact with the alleged victim with initials B, C, D, either directly or indirectly, person and writing by phone, pager, fax, or computer persons. You have to stay at least 500 feet away from this person, the person's home, place of employment, or school at all times. And that also includes, or rather precludes or prohibits is the word, Any contact through emailing, texting, Facebook messaging, or Twitter. Do you understand?
Yes.
Okay, all right. So now let me take a look at the arrest affidavit, and then I'll hear from both sides. All right. Any argument?
Yes, Your Honor. With regard to count 2, aggravated battery, there's no probable cause. The co-defendant, Mr. Sanchez, ultimately ended up leaving and coming back to hit the victim, indicating a break in time there. Additionally, with regard to count 3, strong arm robbery, defendant Byron was the one who actually took the phone from the victim, not Ms. Kuhn. Therefore, there should also be no probable cause found for that as well.
All right, Madam State.
So I think I was just checking on 1 second. Let me just look at the 1 second. All right, so I agree on the ag bat. The strong arm, she may be a principal, but there's PC on count 1.
Do you want to, with regards to counts 2 and 3, is it something that you want to set for further hearing? Probable cause?
No,
No?
no. Not if your honor's finding PC on count 1.
All right, after reviewing the arrest affidavit and other matters, pertinent such as her prior history, the court does find that there's probable cause on count 1. So she will be held no bond. With regards to count 2 and 3, arguments of the defense are well taken. So she'll be released on her own cognizance on that. On counts 2 and 3, because the state doesn't wish to go forward with the probable cause hearing. So, yeah. Yes, sorry.
Your Honor, release outright on 2 and 3, Your Honor?
2 and 3, yes.
Thank you.
And hold for the motion of setting no bond. And there's a stay away order I've already read to her that will be entered. All right. There you go. Full package. Nicholas Floyd. Mr. Floyd, good afternoon. You are before the court. It is alleged that you committed the following offenses on September 22nd, 2025, in the vicinity of 1250 Northwest 79th Street, apartment or unit 206. And that is 1 count of burglary with an assault and battery therein, which is a first-degree felony punishable by life. The alleged victim in this case is a person by the name of Lindsay Sierra, which means that any condition of any release on this case would be subject to this order of conditions, one of which means that you are prohibited from having any contact, direct or indirect, with the alleged victim in the case, who is Lindsay Sierra. That means no contact in person, by writing, by phone, through social media, or through third persons. You have to stay at least 500 feet away from the victim's home, place of employment, or school at all times. Do you understand that, sir?
Yes.
Yes? Okay.
Yes.
All right, in addition to which, the state of Florida has also filed a motion for pretrial detention pursuant to Florida statute section 907.041. All right, I've appointed the public defender's office to represent you in this case for purposes of this hearing, and now we'll take a look at the arrest affidavit and all the documents to address your bond status. All right. Anything from our side?
Your Honor, is it possible if we pass this case and come back to it towards the end of calendar to see if we can get in contact, like we being counsel, of course, with the alleged victim?
Just see if she wants to be.
We want to see if the alleged victim wants to be present.
All right, well, let corrections are able to keep him because this is,
I'm getting a yes from corrections on him.
okay, and we'll pass this together. This is a pass. Here you go. All right, Carlton Whipple.
Your Honor, he also has a hold for the Florida Department of Corrections.
He has what? I'm sorry, I didn't hear.
He has a hold for the Florida Department of Corrections.
Okay.
To confirm, the hold applies to Mr. Whipple?
Yes.
Okay, sorry, I just want to make sure I heard it correctly.
All right. Mr. Whipple, good afternoon, sir. You are before the court because it is alleged that you have committed the following offenses on October the 10th in the vicinity of Southwest 104th Avenue and 174th Terrace in Miami. One count of possession of cocaine within 1,000 feet of public housing, and that's crack cocaine. One count of possession and manufacture of cannabis within 1,000 feet of public housing. One count of possession of a controlled substance, an unknown gummy substance, suspect cannabis, with intent to sell near public housing. One count of possession of cocaine within 1,000 feet of public housing. 0.3 grams, let's see, and tampered with physical evidence. I've appointed the public defender's office to represent you for purposes of this hearing. And I'm now going to take a look at the arrest affidavit and other documents to address your bond status. Corrections, the scroll that he has, is that on F24-17186?
Here's the deal with the whole judge. He is on supervised release until October 12th. So just for a couple more days. He was released from custody on September 28th.
Okay. All right. Any arguments, case?
Your Honor, the defense would like to point out that the A form does not indicate a measurement as to how far away the arrest location was from the public housing unit. Therefore, we believe that this should be knocked down to just the offense itself without the enhancement regarding public housing. Additionally, with regard to the gummies, it says an unknown gummy substance until the arrest form can point out that that gummy substance is actually cannabis. It is a gummy for the intents and purposes, and therefore we believe there is no probable cause as it pertains to the to count 3 with the unknown gummy substance as well. I also want to bring to your Honor's attention count 5, tampering with physical evidence. We believe there is no probable cause because allegedly the defendant just disregarded the bag in front of him. He did not destroy anything. He did not throw it as so far as to make it unable to be obtained by the police. It was a simple distance himself from it. Therefore, we do believe that there is no probable cause there as well.
Okay, so it talks about the incident location being just north of a public housing community, but it doesn't give any specifics on that. So if your Honor wants to set the possession with intent bond, that's fine. So would your Honor do 7,500 on count 1? Counts 2 and 3 deal with cannabis and THC, so maybe 1,000 on each count for that. Maybe an ROR on count 4, which is just like a possession charge.
Gummy. What are you doing with the gummy? That's the 3rd count.
That's right. So the gummies also talk, it says it's a THC suspect cannabis gummy. And then let me see. We could do $1 on that either too, Judge. I'm not so concerned about that. And then the tampering, maybe it's an attempt. They were able to recover it right away. Maybe 1,000.
Your Honor, the defense is okay with $1 on counts 2 and 3. And we ask Your Honor to give the defendant an ROR on count 4 and 500 on count 5.
This all is because of the distance. Why don't you just set this for a probable cause hearing?
I could, Judge, but he's got to hold anyways. I'm okay with setting the possession with intent bond.
Well, the possession with intent to sell the bond.
I mean, Your Honor could even increase the bonds with that finding, taking into account he was just released from his prison sentence a couple weeks ago.
You need to bring in your, when do you want to set this for PC hearing? This gentleman just, I'm sorry?
So Your Honor could find PC for possession with intent. Find PC for possession with intent and then increase the bond based upon his recent prison release.
You need to bring your detective in. Okay, when do you want to set this one?
Tomorrow.
Okay. And set for PC hearing. In the 8th. Here you go. Yeah. DeAndre Shepherd? Did you let him know all the cases? Yeah, mine is the next one. Okay, all right, Drew. Okay. Is this Ms. Shepherd? Yes? Okay.
Yes.
All right, you are before the court for the following reasons. My understanding is the state is alleging that on October 8th of 2025 in the vicinity of 11350 Southwest 216th Street in Miami, you committed the following offenses. Number 1, attempted premeditated murder with a deadly weapon / aggravated battery, 1 count of aggravated assault with a firearm, and 1 count of unlawful discharge of a firearm in a public place or residential property. The alleged victim in this case, or victims in this case, there's two initials, JE and SS. And any conditions of the, or condition of any type of release is going to require you to stay away from both of these individuals, which means you cannot have any contact, direct or indirect, in person, in writing, by telephone, page, or fax, or through third parties. And you must stay at least 500 feet away from the victim, victim's homes, place of employment, or school at all times. Prohibited conduct also includes electronic conduct, such as emailing, texting, Facebook messages, or Twitter. You also must stay away from the following addresses: Joe and Edith Demps Park, which is located 11350 Southwest 216th Street in Miami. Do you understand? Yes? Okay. The state of Florida has also filed a motion for pretrial detention pursuant to Florida statute, in this case 907.041. I've appointed the public defender's office to represent you for purposes of this hearing. I'm going to take a look at the arrest affidavit and all pertinent documents to address your bond status, sir. Okay? All right.
Your Honor, the defense would like to argue that with regard to the first or the murder charge, there's no indication whatsoever of any intent, no indication of any premeditation whatsoever. While we ask Your Honor to knock it down to an aggravated assault with the firearm, because there's nothing in the narrative whatsoever that indicates that he intended to go out and get into a murder fight, especially given that we now have open carry and concealed carry in this state. It's not illegal for an individual to show up to a public space with a gun being concealed. And because there's no indication of him seeking out to murder anybody with a specific intent to do so, we do ask Your Honor to find that that should be knocked down to aggravated assault with a firearm.
I believe there's PC for the attempted first based upon how many times the gun was discharged.
Your Honor, I do want to also point out that while 18 spent cases were recovered, there were 2 individuals shooting. Therefore, we cannot determine from the A form alone how many shots were fired by the defendant himself.
All right. I've reviewed the arrest affidavit. I'm making a finding as to probable causes to count 1. He'll be held no bond. Count 2 is going to be $5,000. Count 3 is going to be, let's see, that's first. It's going to be $500. There's a stay away order in place, which I've read. And in terms of the pre-trial detention hearing, that will occur. Next case is Alan Triana.
Yes, good afternoon. Carlson, on behalf of Mr. Triana.
All
Okay,
I know it's a lengthy A-form, Your Honor, so I'll have a chance to review it.
I just got it.
Yeah, I know, I'm saying it's a lengthy A-form, so I'll give Your Honor a chance to
All
review
right.
it. For a meeting.
Well, let me tell them what the, all right, so good afternoon, Mr. Triana, you speak English? Okay, are your attorneys here before the court? It is alleged that on October 9th of 2025 in the vicinity of 2319 West 27th Avenue, Miami, you committed the following offenses, apparently harassing a victim regarding a capital felony, tampering with physical evidence, one count of that, piercing possession of an armor, piercing of an ammunition, and improper exhibition of a weapon or firearm. And there's also a count of resisting an officer without violence to this person. So the PD has been discharged. And counsel, what's your name?
Carlos Gonzalez.
Carlos?
Carlos Gonzalez.
Gonzalez. Okay. All right, and now I'm going to take a look at the arrest affidavit to determine the bond status on this, okay?
Yes, Your Honor.
All right,
Yes, Your Honor, we do have probable cause arguments.
go right ahead.
Primarily as to count one for harassing a witness or victim when there's an investigation of a capital felony. First of all, the A-form does not mention any witness being harassed at all by my client. The only witnesses that could be possibly harassed in this case would be my client or the two officers who were shot. My client did not harass anyone according to the A-form in reality. And this was not an investigation of a capital felony. The only person who passed away was his brother, Mr. Mason Triana. So there's no capital felony investigation. A capital felony would be a first-degree murder. This is not a first-degree murder investigation. It's an investigation of a police shooting by his brother. So there's no capital felony. So there's no PC for count one. As to count two, tampering with physical evidence or attempted tampering with physical evidence, Mr. Triana, according to the A-form, was asked to produce the firearm that he was engaged with Mr. Triana with during that part of the shooting, which is what brought the police to the scene. He did turn over a firearm, but as he turned it in, he told the police officers, I have two very similar firearms. This may not be the correct one. He never has, till to this moment, he's not denying that he'll give the other one. So there's no, I don't understand why they even count. As to the armor piercing ammunition, we'll wait till that's tested. We'll stipulate to that. We don't have a PCR against that one. The improper exhibition of a firearm, even though the investigation is still ongoing, all reports are that Mr. Allen shot in response to Mr. Mason Shana shooting him the same way Mr. Mason Shana shot at the police unprovoked. I don't understand where the improper exhibition of the firearm comes from. And as far as resisting the officers without violence, I'm not sure what they're considering the resisting. He did turn himself in. He did sit through hours of questioning yesterday without me being present. And I've been his attorney for over 10 years. He has cooperated by giving the firearms, yet he has at no point in time resisted anything from the officers.
All right, thank you, counsel. State.
So Judge, I don't know if Your Honor is familiar with the whole context of this investigation. So if Your Honor looks at the first paragraph on page 2, it looks like the defendant's brother opened fire at him, and then the defendant got an AR-15 and returned fire. Eventually, the police were called out. The defendant's brother barricaded himself in the house. I believe 2 officers were shot, and his brother eventually died as a result of this standoff. So that's the big picture here. And the police are investigating that incident. And that's why they go to the defendant's body shop to get the gun that was used during that incident. And while they're there, the defendant told one of the employees not to cooperate and not to tell the officers where the gun was. So that's the tampering, which is count 1. That's tampering with the witness.
Well, that's if the state's arguing for tampering, we'll agree to that, but that's not the count 1. Count 1 is harassing, which is a very different charge. Because tampering with the witness would involve a standard bond.
Well, you had 2 arguments on the first one.
Well, there's 2. So count 1 is tampering with the witness. Count 2 is tampering
We're
with.
talking over each other. Okay, so I think the counsel, I don't know if you heard him, I think he has dual argument with regards to count 1, harassment versus tampering.
So let's look at the statute.
Okay.
I'll pull it. I believe it is charged correctly as tampering.
And it being or not being a capital felony. That's what the second prong of the argument is.
Yes.
The underlying.
Yes.
Okay, so here's the statute. So it's tampering with or harassing a witness, victim, or informant. So I believe it would be tampering in statute.
And then the second prong is you're charging or enhancing it into a first-degree felony punishable by life because it's alleged that the harassing and or tampering occurred within the provinces of a capital felony.
So the tampering with a witness, it's a derivative offense. So it's 1 degree higher of the underlying offense. So the issue would be, was the gun, was telling, I guess, the witness to not give the police the gun, was the underlying offense counts 3 and 4, or was the defendant tampering with evidence of, I guess it would be an attempted murder of a law enforcement officer, which is his brother's charge, by getting rid of his own gun?
And an attempted murder of a law enforcement officer, does it rise to the level of a capital felony?
Well, no, well, it's
We
so
agree with-
again, it's
but not a capital.
again, it's a derivative offense, so it's 1 degree higher than the underlying offense. So an attempted murder of a law enforcement officer would, I guess, be a life felony. So that would bump it up to the capital, but.
And we would also argue, Your Honor, that my client's firearm, which is what they were trying to retrieve from his body shop, is not related to the offense where his brother shoots at the police. It's related to the shooting between him and his brother. They have nothing to do with each other. My client's gun was not involved in the shooting of the
That's not part of what these 4 corners of this instrument state.
Right.
Well, the
That's
instrument,
going over and beyond.
right, well, that's what we're saying, there's proper cause within So yay.
Okay, the bigger picture is count one, okay? So we have now reviewed the statute, and clearly it really, it speaks about harassment versus and or tampering within the context of the statute. The fact that there is no ab initio capital felony, but you do have a first degree felony with regards to an underlying, because this was an attempt to, that's his argument, attempt to murder two law enforcement.
So Judge, but it may be, I guess what counsel's trying to say, he was tampering with the evidence of the shootout with his brother, right?
That's the allegation. Yes.
He's
So we
saying,
would have
you
to
hear him, he
see,
says that's the allegation.
Right. The reality is my client didn't tamper. An employee of his, which I
It's your argument.
right. Well, he was in police custody, so he couldn't tamper.
Okay, and does then all of these given events, does it qualify to the charges that are being brought or alleged as charged in a capital felony?
so I think Judge, he was tampering with the gun that was used in the shootout with his brother. So maybe tampering with
We're just asking for either an ROR or a bond, because we believe it should be bonded at the very least, because it is overcharged. Even if the court doesn't accept my probable cause arguments for any other count, this count particularly, because the way it's charged is a non-bondable offense, and it's really not guilty of that at all.
But
It should
we're
be.
not guilt counsel. We're here.
Well, there's no probable cause of,
The four corners of that document sets forth the elements necessary to
and it
find
does not. Yeah, I pulled the statute and I pulled the jury instructions for both tampering and for harassment, which are two separate jury instructions with separate language. And the language here doesn't fit either tampering or harassment. He at no point threatened anyone or asked anyone to do anything with that firearm.
Huh? Oh, I don't have the documentation. There were motions. Aren't there motions filed on this? Didn't I just say?
I did not file a motion on this.
All I have is the A form. Everything else is on. Okay. All right. So what's the state's position?
Okay, so I think he was tampering with a witness of, I guess, at first shootout with his brother, maybe find probable cause for at best a second degree, that being a second degree felony, so the tampering would be a first, which would be bondable.
And I think that's what counsel is saying.
Yes.
I think that you look at the A form and pretty much it does express those elements. Now with regards to the tampering and what the other one you said you had an issue, because I think everything else is there.
Everything else is bondable. Considering that, would the state be satisfied with a $5,000 bond as to count one?
As a condition of the defendant's release, the state is requesting that the defendant not possess any firearms. I'll defer to the court as to the amount of the bond.
I'm setting bond and I'm making finding exactly as has been expressed that it's not the underlying offense is not a capital felony. It will fall within the ambit of a first degree felony. Through enhancements, the court is going to set the bond at $50,000 on count one. Count 2 and 3 for each $2,500. And count 4 and 5 for each first degree misdemeanors, and that's $1,000. So you have 50,000, count 1, 2,500, count 2, 2,500, count 3, count 4,000, count 5,000. And prohibition, he needs to understand that if he's able to post the bond, you cannot have any weapons whatsoever, which includes firearms, includes knives, any weapons whatsoever. You understand that? And if you have any, because from reading the A form, there have been many, they have to be turned over to law enforcement officers, the nearest, and get a receipt and file it. Do you understand that?
Yes, I do, Your Honor.
I'm gonna put him on a GPS monitoring device.
Your Honor, considering the issue was with his brother passed away, can we just do
There's
a monetary
no
bond?
Summarily, he's gonna be on GPS until further. I mean, you can address this with the division judge. No roaming. It's level like lockdown.
Your Honor, he owns his own business and his employee was the one who got arrested, so there's no one else to run the business.
Oh, then he's
He's
gonna
not
have to, a lot of people run businesses from home, no roaming, so
It's a
total
mechanic's shop. It's not something you can do.
Council, that's my room, total lockdown. Yes. Plus what? Yes, this is in addition to bond.
Your Honor, can you just quickly state all of that all at once for corrections clarity?
Sure.
Thank you.
Bond on count 1 is $50,000. Bond on count 2 is $2,500. Bond on count 3, $2,500. Counts 4 and 5 each are $1,000. In addition to the bond, he is going to be on a GPS monitoring device, total lockdown. Until further order of the court. And no weapons, no firearms, which I've already read to him. He needs to surrender them to the local police department and have a receipt and file it with the court.
Thank you, Your Honor. Have a good weekend.
Judge, can we take a case out of turn, the one that was for the hospital? I just want to see if I can get an order signed today so he can try to get there today.
Sure. What page is that on?
It's Alexis Alfaro, number 18 on page 6.
Hold on a second. Hold on.
So Judge, the hospital is willing to.
Okay, where is it at? What?
It's on page 6, Your Honor.
6, okay. That's
The case of Alexis Alfaro.
this morning. I just have to locate it. Hold on.
Southern Winds Hospital is willing.
Guys, give me just a chance. Okay, 6. Right here. And it is Alexis Alfaro, 17.
I'm sorry, we address them?
Pardon me?
Number 18, Alexis Alfaro, part only.
He's still looking. Gotta be in here. There we go. Got it. This is the one where the sister came on this, correct?
Right.
Got it. Yes, 3. Family.
So Southern Winds Hospital is willing to accept Mr. Alfaro. If it's okay with you, Judge, I'll send an order over to Judge De La O for signature on your behalf.
So what hospital is it? Southern Winds?
Southern Winds Hospital, yes.
And Your Honor needs to set an alternate bond.
Okay. Yeah, we didn't set, I found probable cause, but there was no determination as to bond, so it's gonna be alternate. Okay. Okay, count 1 will have $5,000 bond, count 2 will be $1,000. Total bonds, the alternate bond will be $6,000.
3 counts?
John,
it's 3 counts.
Hold
There's
on. Yes.
2 counts of aggravated assault.
Corrected. Pardon me?
There are 2 counts of aggravated assault.
Right. Count 1 and 2 will be 5,000 each. Count 3 will be 1,000. And then they will be released to what, Southern Winds?
Yes.
Secure facility, okay. And that's the ultimate bond, and I believe that I also see a 3 stay away orders that were signed by me and read. I'm not sure, I think they were.
Yeah.
There were 3. That's all I was.
Grandma, father. Sister.
Yes, sister, yes, okay.
Okay, thank you.
You're welcome. What's this one? Okay, back on. The calendar. Which one is that? Okay, what pages?
Page 4.
Okay. Alright. Raul Diaz on page 4. Oh,
Yeah.
Good afternoon.
Kevin Diaz on behalf of Mr. Diaz.
Okay.
Your Honor, so we're pulling out of order really quickly. I just want to make sure that and corrections is on the right page.
This is on page 4. Okay, this is
this
Raul Diaz? Yes. Okay, 9 on page 4. Yes, that's your client? Okay, when you are.
I'm his
So-
son and his attorney.
What's your first name?
Kevin Diaz.
Kevin. Just wanted to, I know you said it, but I didn't hear you.
Yeah.
Okay, so I'm discharged from the Public Defender's Office. Kevin Diaz. And we need to get your client.
Your Honor, I would ask for charge 1 if it's
Okay.
okay.
Is this your client? I gotta make.
That's my dad, yes.
Okay, hold on 1 second. Mr. Diaz? You speak English?
Yes, I do.
Okay, all right, I just want to let you know, you are before the court. The allegations are that you committed the following offenses: 1 count of battery on a person 65 years of age or older, and 1 count of attempted strong arm robbery. This is supposedly took place on October the 9th in the vicinity of 6831 Southwest 44th Street in Miami. Alleged victim, I have 1 stay away order, is Margarita Garcia del Busto, with a date of birth of 12/28/1952. So any conditions of release will include a provision that you cannot have any contact with this person, direct or indirect. Do you understand that? You have to stay at least 500 feet away from this person. Do you understand?
Okay.
Counsel, did you say that this was your dad?
Your Honor, if I may. So he lives right now, they live together about less than 500 feet away from where I live. I'd say it's about somewhere between 500 to
Are
600.
you related to him?
That's my father.
Oh, this is your dad.
That's my dad.
Oh, when you said Diaz,
Yeah.
Diaz is a common name. I didn't connect the dots. Now
We
you're
li-
telling me you're related. That's a different story. Okay.
We live about 3 blocks away from each other, so
And who is Margarita?
that's his
Girlfriend?
his wife, they're not married.
Significant other.
His significant other.
Right. Okay.
I would just ask the court if possible. I'm not sure if it's exactly 500 feet, maybe 400 feet.
This is what the
If
stay away order says. But anyways,
if you'd allow me to take care of him, it may be within about 400 to 500 feet, but if he could reside with me in the meantime.
So if Your Honor would just add a provision, I guess maybe handwrite it, that the defendant is allowed to stay with his son at a specific location.
now this alleged victim, is she present? She's here that she can participate? No? Do they live in the same? Do you live?
I live about 3 blocks away in a different building altogether. It's a
And he
high
would be-
rise.
And he would be staying with you.
He'd be staying.
That's what you're saying. Okay.
It's about 3 blocks. It could be 400, 500 feet away from her apartment.
How many blocks away?
3.
That should be more than 500 feet.
3
3 blocks?
I haven't calculated it exactly, Your Honor, but it could be around there. I just don't want to misstate something, but
Right, okay. All right, but it's not.
I
the
can
same
provide the
building.
address to the court.
Concern of the court would be, you're in the same building. You're not.
Different building.
You're a couple of blocks away.
Couple blocks away.
All right. All right, so now let's get to the,
Yeah.
so you're an attorney, just so that I
Yes.
understand. You're the son. And you're gonna be monitoring him and representing him.
Correct.
Interesting.
For now.
For now, the operative. Okay. All right, so let me take a look at the safe form, and we've established, I think, that Ms. Del Busto, the alleged victim, is not present, correct? No.
I don't believe she's here,
Or
Judge.
otherwise. All right.
Yeah,
There's a-
I don't believe she's present with us.
Oh, I haven't seen her. The name.
Yeah, she's not on.
No priors, correct?
0 prior.
No.
He may have
No.
a parking ticket from many, many years ago, but he has a clean record. He's not known to cause any type of trouble, Your Honor.
Mr. Diaz, I just want to make you aware that your father does want to say something really quickly.
He shouldn't be saying anything. He
Well,
should not-
essentially, all he wants to say is that if Your Honor could stipulate to at least a return one time so he could get all of his things because all of his clothing and belongings are at the location.
And I was gonna ask the court if that's possible.
You guys gonna let me do something here? Because the moment I try to open my mouth, somebody else is saying something. Let's do this in an orderly manner, okay? The stay away order provides exactly that he will have one opportunity to go back to the dwelling since they lived together with law enforcement officer, not the son, a law enforcement officer to pick up, okay, his personal belongings. I'll read exactly from the order. Accompanied by a police officer to retrieve his or her personal clothing, personal health items, medication, okay, personal and business related paperwork and work tools, okay? Then it says there, going to the home or remaining at the home without the police will subject the defendant to arrest, okay? The police officer shall, and this happens within 48 hours of the moment of his release, okay? No later than that. Shall request all keys and garage door, okay? Openers to the home from the defendant and return them or turn them over to the victim. So he's gonna be able to go there. It's just in order to go with law enforcement officer, so there's no other problems until you get this squared away. Got that? Okay. And it's one time. I'll see you guys, so make sure you have a little list. When you get there, you get what you need. All right. All right. That's my suggestion. Okay. So now let's get into the actual crux of this, which is the probable cause. Is there any argument as to either of these counts?
I haven't seen the A form, Your Honor. I would ask if it's possible if I.
So Judge, it says that the victim's elderly, but it doesn't specifically give an age. I'm okay with Your Honor setting a reduced bond in light of the fact that he doesn't have any criminal history and we know that he's gonna be staying at a location away from the alleged victim.
Your Honor, he just turned 66 last week. The alleged victim is 70, 69 or 70.
And?
No, I understand this. Just because of the nature of the charge, Your Honor.
Well, it doesn't say it, so they're deficient. And if the A form doesn't say the age, then the court can't make findings that it has with regards to a battery of a person over 65. I mean, they could bring a law enforcement officer that will establish it with the victim, but they've said they're fine with this court making findings. It says here that the victim sustained a bleeding wound to the left wrist as a result of the struggle. But other than that, that's what it is. Okay. So what we're gonna do here. All right, I'm gonna set bond at $2,500 on count one. And on count two, I'm gonna set bond at another 2,500, okay? There's going to be a stay away order. I've already read it to him. Is there any part of what I said to you about the stay away and going back within 8 hours that you didn't understand, Mr. Diaz? Did you not understand something? Do you understand? Hold on. Do you understand that you cannot have any contact? Okay, that you're gonna live with your son.
I understood.
Okay? In the meantime, you will not go anywhere near the sleep. Okay?
Yes.
That if you walk into a restaurant and she's there, you walk out. Okay? You cannot, you have to stay at least 500 feet. We have established that there is no measurement from where you're gonna be residing with your son and the home where Ms. Del Busto is, but you can't go anywhere near that building, okay? Or that immediate area. You understand?
Yes.
Because if you do, you'll be rearrested and you won't go home.
We were attending.
Sir, do you understand what I'm telling you?
Yes.
Okay, that's what I need for you to, and you cannot call her. You cannot have another person send her a message. You cannot use social media, Facebook, texting, no. Okay, make believe that she's not around, that there's no contact. And this is literally what it is, no contact. Okay, so no contact with third parties, through mail, through courier, pigeon, nothing, okay?
We're clear.
Got it? Okay, you can go back within 48 hours. You cannot engage in any criminal activity. That means you can't get in trouble with anything else, because if not, you'll be back here as a violation of this. You cannot possess any illegal drugs. You understand so far, yes? Sir?
I understand, but
You're having a problem with illegal drugs? You cannot possess any illegal drugs. That's what I just read to you.
Que no possess.
Illegal drugs.
Illegal, not legal, illegal,
Yeah.
contraband.
If I may, he has a problem with the hearing aid.
Oh,
That's,
they're explaining, I think, as a friend of the court, they're telling him. No drugs unless they're prescribed.
I'm sorry, Your Honor.
No, assume you work, because he's gonna go to work with you.
He doesn't work. Retired.
No, you.
Oh,
You're saying you're gonna supervise him. On something like this, I would put him on a monitor.
I could try, Your Honor, I have other family members that I could put him with.
Judge, you understand? All right, so you understand no illegal drugs, right?
I also.
Yes.
I understood.
You cannot you can't use, purchase, or possess or carry any firearms, guns,
No,
okay,
there's
weapons,
no.
or ammunition.
Nothing.
If you have any of these or a concealed weapons permit, you have to turn them over to the police and get a receipt, okay? And file it with the court. I already told you about no contact with her. I already told you about not being able to go back to the home within 48 hours of the police officer getting your personal belongings. And that's it. Understood? It's not difficult. Okay,
Thank you, Your Honor.
you're set. Good luck.
Thank you.
Who else had anything on this page? Was there another attorney? Or no?
We have another private attorney,
On which one?
20, David Seltzer here for Mr. Zadikoff, number 20.
I don't see any over. Maybe that's.
He's here. Promote.
Oh, that's you.
On page 11.
I have the page 7.
Yes, so, yes,
It's on page.
Oh, so it's page 4.
the number's 3.
Oh, here it is on the bottom of page 4. Okay.
No, the case is on page 7. Zadikoff.
Morning or afternoon, Your Honor, David Seltzer.
Hi. Thank
Nice
you
to
for
see you, Judge.
forward. Okay, good to see you. No, that's it. That's okay. It's okay. All right, let me make sure I have all the goodies. All right, so this is, just so we're certain, this gentleman right here is Diosdado Alvarez Rodriguez. Is that you?
No,
No, that's not him.
that's Michael Zadikoff.
Okay, who is before me? What's his name? This gentleman.
This gentleman before you right now is Michael Zadikoff, found on page 7 of the calendar.
Okay, that's what the clerk was trying to tell me. I have paperwork here, but it doesn't correspond to this gentleman. Okay, hold on.
And David Seltzer is his private attorney.
Okay, hold on.
Judge, you coming back to criminal court anytime soon?
Yeah, where I don't, yeah, I do. I was just in the case for 2 weeks. I don't see, oh, there you go. Hold on, that's the next one. And now I see you. Now I have a visual. All right, so this is Zadikoff, right?
Yes, Judge.
Okay, so let me get the goodies on this gentleman because I don't have them. Do you know?
And we do have some witnesses, Judge, for the hearing if necessary.
Okay. Well, I'm looking for his paperwork. Here it is, in here. All of this is. Just don't want. Okay. All right. All right, Mr. Zadikoff, good afternoon, sir. You are here before this court because the state of Florida, let's see here, we have an A form that alleges that you committed following offense on October the 8th in Miami, Florida. It says here, engaging in a sexual act with a child. family or custodian. Let me just see. Which is a first-degree felony. They've also filed a motion for pretrial detention in this case. Hold you no bond and pursuant to Florida statute, section 907.041. An alleged victim has initials MZM. Okay, so there would be a stay away order. All right, so this is the first time I'm seeing the arrest affidavit, so let me have a moment to take a look at it. And I'm discharging the public defender's office since he has private counsel. All right, Mr. Southfire, review the arrest affidavit.
Judge, just to count one, our position is it is improperly charged under 794.0118B. It states that the defendant is an uncle. He is not an uncle. We have a witness. He is a stepbrother. They do not reside or did not grow up together, but the alleged victim knows that he is not the uncle, that they are stepbrothers. My understanding after speaking with the family, who the grandmother, who is also the mother who adopted the son at a young age, is present, adopted Michael due to familial issues, but he has been raised by the grandmother. But the alleged victim is having her own issues and has also recently alleged, as of last month, that the stepfather sexually abused her, and a bunch of other cases are ongoing surrounding this young lady that are all under investigation in different counties throughout the state. So, but there is no familial custodial matter at this point. So it is improperly charged as a PBL and should be knocked down to at least at this point an F1 under 794 5A 0115A.
Yes.
There's no specific definition of familial relationship. So I pulled some case law on it. This is what I found. Consanguinity and affinity are strong indicia of a familial relationship, but are not necessary.
Right.
Also, the defendant and the victim need not reside in the same home. The relationship must be one in which there is a recognizable bond of trust with the defendant, similar to the bond that develops between a child and her grandfather, uncle, or guardian.
Right. These are siblings. And I found the same case law, Judge. They're siblings. It's
relationship. Okay.
So I don't. If it's an adult sibling, I think it would still be familial.
Okay. This is the only count I have.
The only one, Judge. Only charge, only
So
arrest.
This is the only count that, and this is a minor that we're talking about. So, I mean,
Right. And then also what I think is extremely telling is that the defendant provided a statement corroborating part of what the
four corners set forth probable cause for the offense. No question about it. Okay. So this court is going to grant the motion for pretrial. I'm going to hold no bond. Okay. He's going to be able to get in front of the division judge and have the motion heard. Okay. If he's able to secure some type of release. Okay. The conditions are going to be as follows, and I need you to understand me. Mr. Zadikoff, you cannot engage in any criminal activity. You cannot use or possess any illegal drugs. You must surrender any guns, weapons, ammunitions that you have in your possession or in your home to the nearest police department. Get a receipt and file it with the court, because you cannot use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You understand that so far? Yes. Okay. As far as the alleged victim, okay, with initials MZM, you are prohibited from having any contact, direct or indirect, with her, okay, which includes contact in person, in writing, by telephone, or through social media. or third persons. Understand so far?
Understood.
Okay. You must stay at least 500 feet away from her home, place of employment, or school at all times. Understood?
Understood.
Okay. Doesn't apply. This doesn't apply. And this doesn't. Okay, so those are the conditions that we kind of.
Judge, can the clerks clarify if it's going to print Tuesday since Monday's not a Monday's a court holiday?
It's scheduled to print out on Tuesday, if I'm being told, because the clerk's office is closed.
Correct.
Holiday. So even though the judges will be in, they're not going to be able to have hearings. So most of the time. All right, so this will print out Tuesday is what I'm being told. All right.
Your Honor, that's
All right, Judge.
I'm sorry?
That's a motion for PTD, no bond.
No bond.
Did they file a motion?
They filed a motion for trial release.
Thank you.
Judge, thank you. Pleasure to see you as always.
Likewise.
Have a nice weekend.
Likewise. Okay, here we go. Okay, are we back on the calendar? Yes. You got to speak up. If not, the train will keep going. Okay, so what page are you on? We have an attorney.
Page 4, Judge, number 11.
Page 4. Okay, hold on. I saw that. There we go. Thank you. That's what the clerk was trying to tell me.
Yes.
Okay. So this is Diosdado Alvarez Rodriguez. Yes. Okay.
Yes.
All right.
Marco Quesada. Yeah.
And is he available? So what you could see if they.
I'm sorry, who you calling?
I'm calling on page 4, number 11, Diosdado Alvarez Rodriguez.
Your Honor, on ours it is number 12, so I just want to make sure that that's clear for all parties.
Oh, so it's indeed. Okay, that's okay.
And Your Honor, can we have the Spanish interpreter available, please?
Okay.
Thank you.
All right.
Interpreter available.
Okay, good afternoon, Mr. Alvarez Rodriguez.
Muy buenas tardes, señor Álvarez.
Your attorney is present before court counsel. What is your full name?
Marco Quesada.
Quesada.
Su abogado se encuentra presente ante el tribunal. Su nombre, abogado, ¿cuál es? Marco Quesada.
Okay. So I'm discharged from the public defender's office.
Estoy
All right,
permitiendo que se retire la Defensoría Pública.
Okay, so you are before the court because it's alleged that on October 9th, 2025, in the vicinity of 398 East 56th Street in Hialeah, committed the following offenses.
Usted se encuentra ante el tribunal porque se alega que el 9 de octubre del 2025, en la cercanía del 398 este de la calle 56 en Hialeah, usted cometió los siguientes delitos.
One count of trafficking in cocaine.
Un cargo de tráfico en cocaína.
One count of trafficking in illegal drugs.
Un cargo de traficar con drogas ilegales.
Methamphetamine.
Metanfetamina.
Okay. One count of possession of firearm by a convicted felon.
Un cargo de posesión de un arma de fuego por una persona que ha sido condenada por un delito grave.
One count of possession, intent to sell or manufacture a controlled substance, alprazolam.
Excuse me, Your Honor, the interpreter did not hear what the controlled substance is.
Xanax.
That's
Okay.
a Xanax. That's what it's.
Un cargo de posesión con intento de distribuir o vender una sustancia controlada, Xanax.
Okay. One count possession of a controlled substance, that being crystal meth, for the purpose of trafficking. But I think that's armed, if I'm not mistaken. Yeah.
Un cargo de posesión en lo que estaba usted armado de una sustancia controlada, metanfetamina, con la intención de venderla o traficarla.
And that's it. Okay.
Y eso es todo.
All right. I mean, it's enough.
I'm gonna
Went to the
standard-
second page.
Yeah, I'm gonna ask for standard bond on these charges, Judge.
All right. I'm sorry. So your argument, I haven't looked at this, so if you give me a moment.
Paso a la segunda página. Pido la fianza estándar, jueza. Un momento, permítame terminar de leerlo todo.
This is through a warrant, right?
Yes, ma'am.
Okay, because it says it has a nebia and no bond.
Esto fue porque hay una requisitoria, ¿correcto? Sí, porque aquí se pide, correcto, aquí se pide que se le retenga pendiente Nevia sin fianza.
Okay,
No argument for PC at this time, Judge.
I'm sorry?
I'm not making a PC argument this time.
Spoken to the state about, I'm just seeing here. All right, let me hear.
So Judge, we're talking about a huge amount of drugs. It's a 15-year minimum mandatory on both the cocaine and the crystal meth.
¿Usted tiene algún alegato en relación a la suficiencia de indicios, abogado? No, su señoría. Usted ha conversado con el fiscal, permítame escuchar de la fiscalía, su señoría. Dice la fiscal, es una cantidad enorme de drogas. En relación a la cocaína, el mínimo obligatorio son 15 años y lo mismo es en relación a la metanfetamina.
Also, Judge, over $100,000 was recovered.
Su señoría, se recobraron más de $100,000.
In terms of criminal history, he's got the conviction for, I guess the fuel. But he,
En términos de antecedentes, él tiene una condena por algo que tiene que ver con gasolina o
so he also has a prior federal conviction for identity thefts.
y también tiene una condena federal anterior por robo de identidad.
I don't know what his immigration status is.
No sé cuál es la situación migratoria de él.
The state's requesting a bond, maybe $150,000 on 1 and 2 with Nebbia.
La fiscalía pide una fianza de $150,000 en relación al primero y el segundo cargo y además Nebbia.
Your Honor, that's an excessive amount of bond. That's tantamount to no bond for Mr. Alvarez Rodriguez. I would ask for a reasonable bond if Your Honor will not set a standard bond.
Pues, señoría, esta es una fianza excesiva que equivale a no darle fianza al señor Álvarez Rodríguez. Le pido a su señoría que le ponga la fianza estándar.
The proffer has been that they confiscated.
I'm sorry?
The proffer from the state has been that they confiscated in excess of $100,000 in cash.
Well,
when they executed this warrant.
Yeah, there's, we can prove where that money came from,
Not-
just for
I'm
purposes of
saying
hearing. Yeah.
Corners.
No, I understand. I understand that,
La
but I just wonder
fiscalía-
what's going on here.
Value. This is a lot of.
La fiscalía ha
Sure.
indicado que se decomisaron más de $100,000. Sí, señoría, nosotros podemos comprobar de dónde llegó ese dinero, pero yo lo comprendo.
All right. There's.
He does have multiple counts, Judge, so it's
he's
gonna
got-
add up.
I know.
So I'm just trying to set it where it's reasonable for him to
But
be
the
able to post
court,
the bond.
the court can, based on certain factors that it must consider, not only his ability, as you have pointed out to this court or arguing to this court, may be limited. This is I'm limited to what I am reading in the four corners of the instrument, and it's a lot of controlled substances. And this is very serious, quite frankly. So I'm making a finding that there's probable cause on all counts. He also has previous convictions, and I think they were set forth. This is not a first time offender. So having said that, and also, and within the four corners that he is entered, waived, made certain incriminating statements with regards to these events. So having said that, this is my ruling as to count one, $100,000 bond. As to count two, $100,000. As to count three, $7,500. As to count four, $7,500. As to count five, $100,000.
Your Honor, on number 5, that kind of includes number 1 and 2 because it's a place, not any additional contraband. So I would ask Your Honor to take that in consideration and make count number 5 $7,500 as well. This is really duplicative of
I
the other two.
understand your argument. And this is the court's ruling. Okay, so counts 1 and 2 will be with Nebbia requirement. Okay.
Excuse me, Your Honor, may the interpreter interpret?
Yes, I'm sorry. Tell
Thank
me
you,
because
Judge.
I forgot your existence. I'm so sorry. Counts
Yes,
1 and 2, $150,000 with Nebbia.
You said 100.
I'm sorry.
En este caso, el tribunal tiene que tomar en cuenta una serie de factores y el tribunal los ha tomado en cuenta, determina que hay suficientes indicios que sustentan los cargos desde el punto de vista legal. Además, me veo obligada a señalar que este acusado es reincidente, tiene antecedentes y que en conformidad con lo que se señala en la declaración jurada de su arresto, él se incriminó en ciertas declaraciones que hizo ese día y hay muchas drogas. Por tanto, en relación al primer cargo, le voy a imponer una fianza de $100,000. En el segundo cargo son $100,000. El tercer cargo son $7,500. El cuarto cargo, $7,500. Y el quinto cargo son $100,000. El abogado de la defensa, el señor Quesada, indica que, señoría, el quinto cargo es básicamente una repetición del cargo 1 y 2. Y yo le rogaría que le ponga una fianza de $7,500. Y la jueza le dice, con todo respeto, caballero, este es el fallo del tribunal, son $100,000 en relación al quinto cargo.
Counts, I don't know if you've said it, counts 1 and 2 have a Nebbia requirement.
Y los cargos 1 y 2 tienen un requisito Nebbia.
Okay.
Okay.
All right.
Thank you.
Good luck. Bye.
3, 4,
Buena
and 5
suerte.
is just straight bond.
Pardon me?
3, 4, and 5 is straight bond.
Yes.
Thank you.
All right, where do we leave off so we can go back on the calendar? I think on page 3. It's Aldana Sanabria.
Yes, correct.
I think the victim may be here. Let's say. I see the victim.
Do you speak
We
English? Do you need an interpreter? Okay.
Thank you.
Terrific. All right, Mr. Aldana Sanabria, you are here before this court because it's alleged that on October the 9th, 2025, you committed the following offenses.
Señor Dana Sanabria, usted se encuentra ante este tribunal porque se alega que el día 9 de octubre usted cometió los siguientes delitos.
1 count of strong arm robbery, 1 count of criminal mischief, $1,000 or more, and 1 count of domestic violence battery.
Un cargo de robo con fuerza, un cargo de daños dolosos, más de $1,000 de daños y un cargo de agresión.
I've appointed the defender's office for purposes of this hearing, and now I am going to go ahead and review the arrest affidavit and all relevant documents for purposes of determining your bond status.
Le nombro a los abogados de oficio para que lo represente a usted y voy a revisar la documentación de su arresto para ver si contiene suficientes para ver qué determinación se va a tomar en relación a su fianza.
The alleged victim is Lindsay Gabriela Orellana.
La presunta víctima se llama Lindsay Gabriela, the last name, Your Honor?
Orellana.
Lindsay Gabriela Orellana.
All right, any argument?
Your Honor, the defense just wishes to address count 2 with regard to criminal mischief. The A form just states the actual value of the phone itself, the iPhone 14, but no actual value of damage, which is what the criminal mischief statute is made to address. And so because there is no damage or no amount of damage listed on the A form, we don't believe that there is probable cause for count two?
¿Hay algún alegato en relación a la suficiencia de indicios? Señoría, deseamos que se nos escuche en relación al segundo cargo, el cargo de daños dolosos. Se alega que el objeto fue un iPhone 14, pero no se indica el valor de ese teléfono. Por tanto, no hay suficientes indicios que sustentan ese cargo porque es preciso que se indique cuál es el monto del daño.
State.
That's fine, Judge. It would be a second-degree misdemeanor, but I'd like to see what the victim has to say.
Eso está bien, señoría. Sería un delito leve de segundo grado, pero deseo saber qué quiere decir la víctima.
Ma'am, if you want to talk to the judge, now's the time.
Señora, si desea hablar con la jueza, este es el momento de hacerlo.
Hola.
Hello.
Hello.
What is your name?
¿Cuál es su nombre?
Lindsay Orellana.
Lindsay Orellana.
Are you here with regards to Jorge Aldana Sanabria?
¿Usted se encuentra aquí en relación a Jorge Aldana Sanabria?
Sí.
Okay, and what
Yes.
do you wish to say to the court?
¿Qué desea decirle a este tribunal?
De mi persona, yo quiero retirar los cargos hacia él. Pues fue algo que se salió de control, algo que podemos solucionar entre él y yo, y por mis hijos, para solucionar en familia.
Un momentito. As far as I'm concerned, I'd like to drop the charges. It's something that is an out of the ordinary situation, something we can fix between ourselves and in order and for the benefit of my children and the family. Adelante.
Want to inquire on state?
So
Fiscal desea preguntar.
usually in these cases, the judge issues a stay away order.
Modified, I understand that. Are you
Does Your Honor
afraid of him? I mean,
do you want the judge to issue a stay away order?
Señora, ¿usted desea que la jueza expida o emita una orden de alejamiento?
No.
No.
You feel safe if he comes back home?
¿Usted se siente segura si él regresa a casa?
Sí.
Yes.
Did you get your phone fixed or not yet?
¿Usted logró que le arreglaran el teléfono o todavía no lo ha logrado?
Sí.
Yes.
How much did it cost to fix?
¿Cuánto costó?
1,060 y algo.
60 something. 1,060 something.
To fix it or to get a new one?
¿El arreglarlo o el adquirir uno nuevo?
Sí, adquirir uno nuevo.
Yes, to get a new one.
So you couldn't fix it?
¿No lo logró arreglar?
No, todavía no.
No, not yet.
No ha llegado.
Not yet. It
Solo
hasn't
hice
arrived.
La orden.
I placed the order.
Judge, with your permission, may I ask the AV a question?
Yes.
Thank you. Ma'am, did you attempt to get your phone fixed or did you just go right ahead to get a new one?
Señora, ¿usted trató de que le arreglaran el teléfono o usted sencillamente fue y se compró otro?
Se hizo una orden de otro.
An order was placed for another one.
But ma'am, did you try to get the phone fixed?
Pero señora, ¿usted trató de que le arreglaran el teléfono?
No.
No.
It says a misdemeanor, it's fine.
Es un delito menor. Está bien.
all right, so let me explain to you. You obviously, Ms. Orellana, have to meet with the state. It's going to be their decision whether they're going to prosecute this case or not.
Bueno, permítame decirle lo siguiente. La señora Orellana tendrá que hablar con la fiscalía. Usted la escuchó y la fiscalía será los que deciden si van a seguir adelante con este juicio suyo o no.
Okay.
So at this juncture, these are very serious offenses. The court has listened attentively to what you have to say. So I'm going to, and I want you to understand what this court is going to do is enter what's called a modified stay order.
Entonces, estos son delitos muy graves y el tribunal ha escuchado con gran atención todo lo que usted ha dicho. Entonces, escuche con detenimiento lo que le voy a decir. El tribunal va a dictar una orden de alejamiento modificada.
He is going to be able to go back home with you, but he is prohibited from being physically threatening or violent towards you in any manner whatsoever.
A él se le va a permitir que él regrese a casa con usted, pero a él le está totalmente prohibido que él la amenace o que sea violento hacia usted de cualquier manera.
Okay, the law enforcement were involved in this. Okay, they have photos of injuries, and this is exactly how people end up dead. Okay, so
La policía se inmiscuyó en este caso. Ellos tienen fotografías de lesiones y alguien pudo haber muerto.
okay, so is it? Are you going to agree to comply with this? And most importantly, I have to ask him if he agrees that you're going to comply, that you can go back home, because she stated on the record that she's not afraid of you, that this was a misunderstanding, and that she wants you to come home. But you can go home, but, and I'm paraphrasing, you are prohibited from being physically threatening or violent towards her in any manner whatsoever. You understand?
Bueno, ¿usted está de acuerdo con hacer esto, caballero? Usted escuchó lo que ella ha dicho, que esto todo fue un malentendido, algo así, pero usted está de acuerdo a no actuar de ninguna manera amenazadora ni físicamente agresiva hacia ella.
Nunca más.
Never again.
Now we have to address the bond status. I mean, with the exception of the criminal mischief and the amount, there's probable cause for every single thing here. Okay.
Ahora vamos a ventilar lo de la fianza. Con la excepción de el daño doloso, que es un delito leve, hay suficientes indicios que sustentan todos los demás cargos.
I'm going to set bond on count 1 at $5,000.
En relación al primer cargo, su fianza son $5,000.
Count 2 at 100.
El cargo 2, $100.
And count 3 at the lower end, 500. So the
Y
bond,
en el tercer cargo, hacia lo bajo, $500.
so that's total of $5,600 for
En
bond
total son 5,600.
and the modified state order.
Y la orden de alejamiento modificada.
All right, good luck.
Buena suerte.
Next case is Jordan Evans.
Thanks. Y'all know on his traffic case, he received 150. And he also has a fugitive warrant from Franklin County, Texas.
From Texas. Okay. All right, good afternoon, Mr. Evans. You're here because it's alleged that on October 9th, in the area of 10035 Northwest 7th Avenue in Miami, you committed the following offenses, sir. Fleeing a police officer, resisting an officer without violence, and the traffic, which is the one that was alluded to, no valid driver's license. I've appointed the public defender's office to represent you. I'm going to take a look at the arrest affidavit and to determine your bond status. I'm being told you have a fugitive warrant from Texas. Let's see. All right, it's probable cause here. I'm gonna set bond on count one at $2,500, count two, $500. So total bond is $3,000. Top of page 4, Kataj Hodges. Kataj Hodges. Mr. Hodges, good afternoon, sir.
Good afternoon, Judge.
You're before the court because it's alleged that on August 31st, 2025, at the Walgreens store located at 23201 Southwest 112th Avenue, you committed the following offenses. It says petty theft, having 2 or more convictions, which becomes a felony. All right, I've appointed the public defender's office to represent you. And now I'm going to take a look at the arrest affidavit. And I see that you have,
Your Honor, these are added charges.
these are added charges? Okay,
Yes.
okay, all right. Okay. The A form doesn't express the prior convictions unless
It doesn't, but here's his DOC information. The defendant was released from prison July 15th, 2025, for charges including petty theft, 2 or more convictions. He's got multiple convictions for theft.
well, he was, I believe the printout I have looks like on April 4th of 2024. It looks like he was sentenced to 24 months for petty theft, 23,192. Those ones you just put up?
Yes.
$2,500 bond. And a stay away order. Sir, if you're able to post the bond, you can't go near that Walgreens, okay? All right, good luck to you. Santiago Perez Toro, still on page 4. That goes with that.
I'm sorry, who did you call?
Perez Toro Santiago on page 4.
He's a bond out.
Bond out. Page 5. Leonil Rubalcaba. Is that you, Mr. Rubalcaba? Do you speak English?
No, we need a Spanish interpreter, please.
¿Es usted Leonid o Leonel Rubalcaba?
All right, Mr. Rubalcaba, you are before the court, sir, because it's alleged that on October 9th, in the area of 3251 East 2nd Avenue in Hialeah, you committed the offense of trafficking in cocaine.
Señor Rubalcaba, usted se encuentra ante el tribunal porque se alega que el 9 de octubre del 2025, en la cercanía del 3251 este de la Segunda Avenida en Hialeah, usted cometió el delito de tráfico de cocaína.
I've appointed the public defender's office to represent you.
Le nombra a los abogados de oficio para que lo representen.
And now I'm going to take a look at the arrest affidavit, sir, to determine your bond status.
Ahora voy a revisar la declaración jurada que sustenta su arresto para ver si contiene suficientes indicios de criminalidad.
Okay. Hmm. 58 ounces, 58 grams, I'm sorry.
58 gramos.
All right, there's probable cause.
Hay suficientes
Um,
indicios.
What does the state and the warrant underneath had a requirement for Nebbia?
The state's requesting 25,000 with Nebbia.
¿Qué me pide la fiscalía? La fiscalía pide fianza de $25,000 más Nevia.
Your Honor, defense asks that you set a bond at 15,000 and remove the Nebbia hold. The defendant has no prior convictions. And given the weekend, it's going to be a long time. It's going to delay his ability to be released. A 15,000 is a significant amount of money anyway. So we ask Your Honor to consider that.
Has anybody done
Señoría,
any-
la defensa pide que se le imponga una fianza de $15,000 y que se le elimine el requisito de Nevia. Este acusado no tiene ninguna condena anterior y este es el fin de semana, se le dificultará el salir. Por tanto, pensamos que es razonable imponerle una fianza de $15,000 sin Nevia.
$20,000 bond with Nebbia.
Fianza de $20,000 con Nevia.
Leonard. Is this Mr. Moore? Good afternoon, Mr. Moore. All right, you are before the court because it's alleged that on October 9th, sir, in the vicinity of 2030 Northwest 67th Street, Unit 201 in Miami, you committed the following offenses. 1 count of attempted armed robbery and 1 count of aggravated assault with a deadly weapon. I have appointed the public defender's office to represent you, and now I'm going to take a look at the arrest affidavit and all relevant documents to determine your bond status, okay? Oh, wait a minute, before I forget, the alleged victim in this case is a person by the name of Tashika Brown and Zachariah Brown. And there is also a motion for pretrial detention filed by the state of Florida pursuant to section 907 Florida statute .041. So they're asking to be held no bond. Any conditions of release today or at any point in time will include, just so that you know, a stay away order, which says that the conditions of your release will require you to stay away and have no contact with these alleged victims, which means no contact directly or indirectly or through third persons. You can't contact them in writing, by telephone, pager, or fax, okay? You have to stay at least 500 feet away from their home, their place of employment, or school at all times. And also electronic contact is prohibited. That means no emailing, no texting, no Facebook messaging or Twitter. And you have to stay away from the residence, which is located at 2030 Northwest 67th Street. Do you understand that, sir? Okay. Well, let me take a look at the uniform real quickly.
The state's asking that the court find PC for an armed burglary and hold the defendant without bond.
I'm sorry, Miss, did you say armed burglary or armed robbery?
Well,
No, I heard.
armed, I think it's charged as an attempted robbery home invasion, but I think it's a completed armed burglary, requesting that the defendant be held without bond.
I thought you said. Anything from the defense?
No argument.
Okay. All right, the court is going to make the following findings. The four corners of the instrument, the A form, does set forth probable cause for burglary. I'm gonna hold no bond. The stay order is in place. Also with regards to count 2, 5,000 bond. Pardon me? Oh, right.
Right,
Well,
the victims are here, so
I'm
just
sorry.
so you know, the judge did find probable cause, is currently holding the defendant without bond and issued stay away orders in your favor. If you have any questions, let us know.
You stood, defendant. Yeah. Delano Robinson. Is this Mr. Robinson?
Yes, ma'am.
Good afternoon. Mr. Robinson, it's alleged that on October the 10th at the Catalina Hotel located at 1732 Collins Avenue, Miami Beach, you committed the following offenses: 2 counts of battery on a law enforcement officer, 2 counts of resisting an officer with violence to his person, 1 count of resisting an officer without violence to his person, 1 count of trespass onto property after warning. That's it. I'm appointing the public defender's office to represent you. I will take a look at the arrest affidavit and all the other documents to determine your bond status. There's also going to be a stay away order that if you are released, you have to stay away from the Catalina Hotel at the address that I told you. You understand? Yes? Okay. Any argument?
Your Honor, with regard to count 3, but the second offense, resisting officer with violence to his person, because there was only 1 arrest, we just believe that there's only probable cause for 1 count of resisting, not 2.
So I'll stipulate to an ROR on count number 4.
ROR, she's saying on count 4. Because there's 2 counts of resisting an officer with violence. Okay. Okay, there's probable, as to count 1 and 2, there's probable cause, it'll be 5,000 each. Count 3, 5,000. Count 4, release outright. Count 5, trespass. Actually, it's without. Count 5 becomes resisting an officer without violence. $1. Count 4, trespass. $2.50. And I think that's it with the stay away order. So that's count 1 and 2 each. That's actually counts 1, 2, and 3 each $5,000. Count 4 release outright. Count 5 $1. Count 6 $250 with a stay order. Arian. Mr. Cruz, you speak English?
Yes, ma'am.
Okay, all right, good afternoon. You're here before the court because it's alleged that on October the 10th, at the Starbucks kiosk located at 11401 Northwest 12th Street in Sweetwater, you committed the following offenses, sir. 1 count of battery on a law enforcement officer or corrections officer. 1 count of fleeing and eluding a police officer. 1 count of resisting an officer with violence to his person. And then there's a count of reckless driving. I've appointed the public defender's office to represent you for these proceedings. And now I'm going to take a look at the arrest affidavit and see about the probable cause in your bond. He's had other contexts, but it looks like there were no action. Any anyone?
Your Honor, with regard to the battery of a police officer, the arrest form alleges that that essentially the defendant was driving through the officer on the scooter, and battery requires that mental state of intent to actually commit harmful contact, and that's not what the defendant was doing. He was just attempting to essentially, well, the officer was attempting to grab him, which is what essentially resulted in that collision. It was not the defendant attempting to collide with the police officer. Therefore, that intent is not there.
State, want to respond?
Yeah, it looks like it said that let's see. So he refused to stop and then collided into the officer. So I think it was an intentional act.
The intent, though, to not make contact. The collision itself was not intentional. They were claiming that he's fleeing. So if he's leaving, he's not intending to make contact with the officer.
I think those are final determinations at a trial. This one I'm going to do. I'm going to set bond. I find probable cause. I'm going to set bond on count 1 at $500. Okay. I'm going to set counts 3 and 4. Just see something. All at $500. Okay.
Your Honor, just to clarify, all 3 or 4 counts are 500 each.
No, I'm doing 1 through 3, 500 each.
Just wanted to make sure I heard you correctly.
The other one's a reckless driving. That's it. Traffic, right? I don't need to take care of that here.
Correct.
No, that was just next door.
Got it. Okay, so counts 1, 2, and 3, 500 each. Okay. Good luck, sir. Steve Robinson.
Bond out.
Sean Thornton. Sean. Mr. Thornton, good afternoon, sir. You are before the court because it's alleged on October 9th of 2025 in the vicinity of Northeast 135th Street and 14th Avenue, North Miami, you committed the offense of possession with intent to sell fentanyl. I've appointed the public defender's office to represent you. I'm going to take a look at the arrest affidavit to determine bond status. State what's in this case.
So it's possession. And pretrial is okay, and hopefully he'll get some treatment.
Your Honor, the defendant is actually very, very, very open to treatment. That is exactly what he's hoping to get out of this. He was actually sober for 7 months and had a little bit of a slip up. So if we could bind that down to possession, because
that's what I think.
Yeah. No, I know. Yeah.
So peace. There was, I think, what was it, like less than 2 grams, and then we're talking about a couple of, I think, what, three baggies. All right, possession. $25. What's the thought process here? He's going to be referred to what?
He may qualify for drug court.
Drug
which
court?
if he completes successfully, then he can get the case dismissed.
Okay. So how do we make that happen?
I think it's got to go through the normal process. I don't think we can refer it straight from here, but he should definitely talk to his public defender about it.
Okay. Possible drug court then. Referral. But I can't do it from here. In other words, it's gotta
I don't
be-
think, Ms. Corey, we don't do it straight from here.
Okay.
We haven't done it like that.
All
in a
right,
long
so I'm finding probable cause as to possession of a controlled substance, i.e. fentanyl, setting bond at $2,500. That's it. Okay. Yvonne Vito on page 7.
NBC set for tomorrow.
Tomorrow?
Counsel, you want to waive his presence?
It's an added charge.
Yeah.
Yeah. This is on Vito. He's now before the court instead of setting it for tomorrow. This is an added charge, introduction of contraband into a jail facility. You waive his presence.
You called Mr. Vito, right?
Yes.
You can waive his presence.
Okay. All right, standard bond 2,500. Yesmel Figueredo. This is also an added charge, is my understanding.
Yes.
Judge Your Honor, Mr. Figueredo went to county court this morning.
Oh, he's here?
You want to waive his presence?
No.
I think he's no bond on a probation warrant, Ms. Corey.
We don't have a jail card.
Okay, so let's reset it. NBC?
Okay.
He went to county court today.
Okay, I thought this morning, that's why I thought that perhaps he might be. All right, so you want to reset this for tomorrow then? This is an added charge, grand theft, 3rd degree, but they don't have a card. So reset October 11th. AM. Okay. These are reset for tomorrow. Okay. Darren, is that Mr. Smith?
No, Your Honor, this is Mr. Floyd, found on page 2.
Smith.
Oh, hold on.
Mr. Smith is in Ward D.
No, Smith and Mr. Coley is set for tomorrow, Ward D.
Both of these? Hold on, let me just write this down. Smith. Okay, this is the one reset, which is wholly awesome. Yeah. 1 sec.
If there's anybody here for Mr. Floyd, if you can raise your hand in the chat, please. Okay.
Okay, so this is Mr. Floyd?
Yes, Judge, I was just told by my staff that Ms. Sierra is going to be logging in a second.
Okay.
I think she was here and then had to leave and came back. I think that's what happened.
Corrections, what happened on his misdemeanor?
He reset for tomorrow. It's a DP case. 21.
So Judge, that's a domestic violence case with the same victim from earlier this morning.
That is confirmed, Ms. Seth?
Yeah, that's a domestic DV
So
case,
that
same victim from this morning.
So it's the same.
I mean, I'm looking at the A form on that case, and it said that the victim, defendant is currently the subject of a protection order. I think Your Honor should just handle the case now.
Violation of injunction, so there's an injunction in place.
Right. And that's from, the time of the incident was 12:34 this morning.
Okay. Mm.
Miss Sierra, here, if you can please raise your hand. So just my understanding, she had to leave work to be able to get on Zoom.
Okay, I'm gonna.
Judge,
This is
I
all
pulled,
that's holding up this calendar from being.
it's the last case. Judge, I mean, I think, so there's a DV injunction. It's set for a hearing later this month with the same victim.
It's a violation of a domestic violence injunction is what
Right.
it says in here.
Right, so she has an injunction against him. There was a domestic violence case just after midnight, and this is a burglary with a battery. Would you want to just?
It could always, I mean, it could always be addressed by the subsequent judge, but I reviewed the arrest affidavit the first time around. I said I was ready to make my findings. This articulates a burglary, an armed burglary, which is no bond, okay? There's gonna be a stay away order entered in place. The motion for pretrial detention filed by the state is being, they can go to proceed to hearing. I'm holding a bond so they can grant it so they can hold a hearing. And that's it. If there's something changes along the way, but it looks like these parties have already had issues. There's already an injunction in place, and state, I don't have that information, but she's proper to the court as an officer of the court that it involves the same victim, okay? And that this renewed incident occurred early this morning. So that's my rule, no bond. And just so, Mr. Floyd, if you are able to be released, and that could happen, when you go in front of a subsequent judge, part of the conditions of your release are that you cannot engage in any criminal activity. You cannot use or possess any illegal drugs. You cannot use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender all your firearms and ammunition, concealed weapons permits to the nearest police department, and obtain a receipt to be filed with the court. You are prohibited from having any direct or indirect contact with the alleged victim, Lindsay Sierra, including contact in person and writing by phone, through social media, or through third persons. You have to stay at least 500 feet away from her home, her place of employment, and school at all times. You understand that, sir?
Yes.
All right. Good luck to you. Okay. That's a wrap.
Thank you, Judge. Have a great weekend, everyone.
Thank you very much for all your help, everyone. Pleasure to see everybody. Okay. Do you discard these?
Yes.
Those that travels with them.
I'm sorry.
A lot of these cases.